Both the petitioners are allowed to go on bail of rupees 1 lakh with 2 sureties of like amount with certain conditions.
Obliged.
May I please, Your Lordship? I recommend item number 16, my lord. 16.
Yes.
FSL report has not been received, my lord. Lordship, may I give a reminder, my lord? 16. 16, item number 16.
Yes, Mr. Bhattakur.
Item number scan copy received, my lord, TCR.
FSL report was called for. That is very important, my lord.
How you came to know?
No, my lord, in the two occasions, my lord, that has been called but has not been received. I have checked the,
You have checked the
yes, my
record.
lord. Check the record.
Call for the,
True register obtained by the PP, my lord, additional PP.
We'll pass the orders after perusing the records.
My lord. Obliged.
My lord, I beg to mention item number 2 of the code number 22, my lord. There's some urgency,
Code number-
48 days delay, my lord, 48 days behind the bar. So may I pray maybe taken tomorrow, my lord, or day after tomorrow as your lordship, my lord. Item 2,
Item 2 of court number
22.
22.
Right.
Give a
Tomorrow if
mention.
possible, my lord.
Record I any?
Maybe adjourn, my lord, to tomorrow day after.
You submit the mention memo.
My lord, matter is listed, my lord. That is why.
Yes, we don't have. Where is the notice? No. For listing of, for listing of urgent matters only. Mentioning has to be. Other matters are
My
different.
lord, obliged.
the motion matter of that, code number 22.
It is deferred. No mentioning. Registry will list it. Because records are not before us.
May please, your lordship, I beg to mention for listing in the criminal, my lord, in criminal revision petition. My lord, next week, my lord, and they can come.
Next week on a date to be fixed by registry.
To item number 7 from court number 22, lordship. There is a mistake, lordship, by mistake, birth certificate.
Matters are deferred. It will be listed. Only urgent listing is,
My prayer is, lordship, I may be allowed to annex the birth certificate, lordship. In the
no,
petition.
when the matter will be listed again, then you can make prayer.
Deeply obliged.
May I please, your lordship, I beg to mention item number 12, your lordship, and senior assistant chief is 0, your lordship.
Item number
12, your lordship,
of this court.
of this.
Item number 12. List this matter before any other bench without me. Within bracket, my Munnamdibu.
Deeply okay.
May it please your lordship, I beg to mention for listing of an IA matter, my lord, IA for bail. My lord, accused person is in judicial custody more than 1 year after passing of an judgment. So,
in criminal appeal
yes, my lord.
next week.
Also, with the concern of the other side, I beg to mention item number 47, up to the supplementary list. Also, the dealing counsel, Ms. R.D. Majumdar, has some personal difficulties. A matter may come up on 20 November, lordship.
47.
47.
Heard Mr. S.P. Sharma, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the engaged counsel for the petitioner,
Appellate.
for the appellant, Ms. Adi Majumdar. He submits that he has informed the learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection regarding the prayer. let this matter be listed.
20 November.
No,
Lordship,
in the third week of November on a date to be fixed. You don't,
Because they are only taking adjournment, this is hearing matter.
It is 18 matter,
And
by
the-
that matter.
the-
I'm
Yes,
responsible.
for-
date will be fixed, but by registry. Third week of November on a date to be fixed by registry.
May I please, Lordship? I'm praying for listing of the IA criminal, Lordship, it's for condemnation of delay. Matter was last listed on 29/8, thereafter it has not been listed. Lordship.
Next week on a date to be,
17, the matter is fixed in the trial court, Lordship. Is a delay condemnation. Can it be on Friday, Lordship, 14th?
what is the matter?
Regarding that, we have wanted to annex some evidence which has been rejected by the trial court. And the matter is related to 302. Lordship.
Okay, Friday.
Lordship, other female petition, Lordship, it has not been listed since 25/6, Lordship.
Second, third week of November.
Yeah, so I beg to mention for listing one criminal petition, my lord, matter regarding crossing of the charge sheet, my lord. Last occasion, notice was issued, my lord. This is a listing for urgent, my lord, for in the trial court, my lord.
When notice were issued?
Notice was issued on 26/9/2025, my lord. In the trial court, my lord, dated fixed on 15, my lord. It was, can it be on listing on Friday, my lord?
No, next week on a date to be fixed by registry.
Most of them.
Also, I beg to mention for interlocutory application in criminal appeal, it is for suspension of sentence. Not to any date in the next week.
Next week on a date to be fixed by registry.
May it please the Lordship. Lordship, I pray for listing of a bail application. I am behind the bar for 82 days.
When have you filed?
Yesterday. I am behind the bar.
Then no mentioning, it will be listed within 2 days. If it does not get listed, only then you have to mention. You have to wait for the period, gestation period.
I am behind the bar for 82 days.
All are behind the bars.
May I please, the Lordship? My lord, one matter was listed before the court number 22, my lord, item number 41 at 2 p.m. my lord. Having regard to the urgency of the matter, my lord, this is a bail petition pending disposal of the appeal.
It is a listed matter.
Yes, my lord.
Listed matter registry, matters are deferred. For listed matter, no,
Provided, my lord, if urgency is there, my lord, mentioned to be made before your lordship. So, my lord, kindly matter may be taken up, my lord, on Friday, my lord. It is a appeal number 1 since, my lord, January of this year, my lord, pending disposal of the appeal, my lord, bail petition.
no,
is not
you pray
disposed.
before registry. Pray before registry. Yes,
Please, Lordship. I pray for listing for criminal revision petition from your Lordship for order.
when have you filed?
It was filed
Next week on a date to.
40,
You don't know when have you filed and you.
it's 14/11, last date was.
Next week.
Good morning, sir. Sir, I'm petitioner in person, sir. Item number 42 for today, sir. The case was admitted on, it's a criminal revision petition. sir.
Which court?
Sir, sir,
This court.
sir, I'm getting different courts. Last 5 courts I have. Sir, this is the 7th day I'm appearing for hearing.
No,
sir.
which court your item is mentioned?
In this court only. 42, for today, sir. Sir, this is the 7th day I am appearing for hearing, sir. If
What
we
is your
can-
prayer?
It's a criminal revision petition, sir.
No, what is your prayer?
For quashing the order.
Now,
of-
why are you mentioning? Now you wait for your turn. Till the matter, when the
Earlier,
matter,
because of the paucity of time and deferment of the court, I couldn't get any last 7. This is the 7th day of.
your prayer is for upgradation.
Yes, sir.
Today upgradation may
Yes,
be
sir.
difficult.
Before lunch break or-
Court is rising earlier. So you
Yes.
have to wait for your turn. Please wait.
May I please, Lord? My lord, I beg to mention item 4, my lord.
Of this court.
Yes, my lord. This could be.
Yes.
My lord, I want to withdraw it, liberty to file a fresh, my lord.
Criminal case
It is a
liberty.
new case, my lord, today first listed. My lord. There is some clerical mistake in there, my
Okay.
lord, so I.
Heard Mr.
M.H. Chaudhary.
M.H. Chaudhary. Learned counsel for the petitioner who prays for allowing the petitioner to withdraw the instant criminal revision petition as some typographical mistakes have crept in the petition. He also seeks liberty to file the fresh revision petition. The prayer is allowed. This criminal revision petition is dismissed on withdrawal with the liberty sought for granted.
May I plead your lordship, lordship listing of a bail petition. It was last listed on 29/10. LCR was called for, but date was not fixed.
Next week.
Great legal lawsuit. Item number 33, today's this manner. My private audit service is completed, my learned friend appeared, but my learned counsel informed me the CD is up to the sent to again, my lord, is not come, my lord. And there is no entry, my lord. So matter is taken on Friday, my lord. Let us see, my lord.
Case diary is not there. Friday you can bring the case diary.
My lord.
They would be convenient for us.
3 months already, my lord, he is, my lord.
Friday again, you will be making same prayer. Let it be on Monday. Minister,
Friday, man. Yes, my lord, he can do, man. Friday, man.
item number 33, your name is not there.
Yes,
Heard
madam,
Mr.
N.
N.
Bora.
Bora, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor, who prays for some more time for production of the case and the prayer is allowed. Let this matter be listed on
I do.
14th of November.
Machule.
Your lordship, the mention is for listing of matters. It's a IA for Potco. It's for suspension of sentence.
Next week on a date to be fixed by registry.
Your lordship, with the consent of the other parties, I beg to mention item 40 for 2 weeks, please.
40.
40.
What is your name?
Kaushik Gautam Chaudhary, your lordship.
Heard Mr. Kaushik Gautam Chaudhary appearing for
My senior counsel, Mr. J.M.A. Chaudhary.
Mr. J.M.A. Chaudhary, learned counsel for the petitioner, who prays for an adjournment. He submits that he has informed the learned counsel for the respondents regarding his prayer for adjournment, who has no objection to his prayer.
Lordship may fix a date, lordship. I am for the respondent, lordship.
Also, Mr. N. Rahman,
M. Ahmed.
M. Ahmed, learned counsel for the respondent, who does not have any objection to the prayer. Let this matter be listed in the last week of this month on a date to be fixed by registry.
Your lordship.
May I plead the lordship? Lordship, in tomorrow list of this honorable court, lordship, item number 41 is listed. There are three same matter, lordship. The other, only one matter has been listed, two has not been listed together. Earlier occasions, all the three matters has been listed together. Same matter, they are coming for passing for the same proceedings, lordship. And the IA, all the three matters, there is IA, and IA are all the same petitioners have filed to
So
impeach them.
what matters you want to get listed?
IA
You
for-
give a mention memo allowed.
Lordship for withdrawal one criminal petition tomorrow.
Okay.
May it please the lordship. I make to mention, criminal petition 1046. This matter was listed earlier on, in the month of August, lordship. It's a motion matter. If the urgency is there, lordship.
Motion matter.
Motion matter.
When do you want? Day after tomorrow.
May I plead your lordship, I beg to mention for listing of a criminal petition for admission column next week, my lord.
Next week on a date to be fixed by.
May I please, lordship? Lordship, prayer for listing IA criminal.
Next week.
Lordship, simple correction, lordship, typically mistake in.
Next to next week.
Lordship, I beg to mention item number 29. CD is not available.
Yes.
20.
What is your name? Heard Mr. M. Alam, learned counsel for the petitioner. Also heard Mr.
Charge sheet yes.
Charge sheet
No,
submitted.
no, CD, charge sheet submitted. In this case, Mongol CS number 192.
Wait for your turn.
29.
And please, your lordship, I beg for listing of an AB tomorrow, your lordship.
Day after tomorrow.
Much obliged, your lordship.
May I please your lordship, item number 20 lordship, call for the serious CD not received lordship. This charge sheeted case. 20 lordship,
Charge sheeted case.
lordship, trial is going on,
20 and 21 scan copy of TCR received, madam.
received,
Received.
Yes,
but CD not received.
TCR CD to 9.
Nine.
Mm.
Wait for your turn.
Obliged.
Lordship, I beg to mention for the listing of a bail. He was arrested under section 105,
When have you filed?
yeah, 10/10/11/25, yesterday.
Day after tomorrow.
Much of.
Item number 1.
May I please, your lordship. So here, what has happened, lordship, the petitioner before lordship is a person working in the Indian Army, lordship. He retired as a sepoy, lordship. Now, the code below, without taking into consideration the assets and liabilities to be filed by the parties, have passed the impugned order, lordship. Lordship will find the impugned order, the operation portion of the impugned order in page 129, lordship. Whereby a maintenance amount of rupees 15,000 has been asked to be paid. Now, lordship, the interesting thing, fact is this, I being a pensioner, lordship, my pension is 30,000 and 33,000. And I am having, lordship, my old parents who are residing with me. And I have a loan also, lordship, these facts were not considered. And then without asking the parties to find the assets. and
When
liabilities,
is the order was passed? 22/9.
lordship,
Yeah,
we
we are
kindly see-
issuing notice.
Okay.
Heard Mr. A. Bhattacharya.
Pray for a stay, lordship, because.
Not now, no,
Lordship,
not now.
assets and liabilities have not been asked for.
No, we'll examine that, not now. Let her appear. Heard Mr. A. Bhattacharya, learned counsel for the petitioner. This application under section 438/442 of BNSS has been filed by the petitioner, namely Saidur Rahman, impugning the order dated 22/9/2025, passed in FC within bracket criminal case number 141/2021 by the learned Principal Judge Family Court Barpeta, directing the petitioner to pay a monthly maintenance allowance of rupees 15,000 in total to the respondent and her minor daughter. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 18th of December. List according.
Lordship parts with this record, lordship. Another order that has been passed in 17/10/2025, lordship, may kindly see page now 132 for a moment, lordship. Area of 5,70,000 I have been asked to pay.
That
If
also
we-
you are challenging.
Yes, lordship. Because I am here, what I am challenging, lordship, this is an area amount which has culminated out of the entire proceeding. This amounting to 1,90,000.
That area is subject to some interim order passed
Yes,
earlier,
yes, yes.
which you have not
Yes.
followed.
So I am not on that, lordship. What I am on before, lordship, is 1,90,000 will be difficult for me to pay, lordship.
No, if you accumulate area, it will be always difficult for,
Because there was stay order from this honorable court, lordship, earlier.
now stays vacated.
Stay that.
Okay,
will be given
let
to
her
the
appear, let her appear.
In that case, lordship, may kindly observe one thing, that 1811, considering that it is subjudiced, I need not pay anything, lordship.
No, no such order. wait for appearance of the
Then-
second
then
part.
can I pray that it may be listed before 1811, Lordship? I shall take steps today itself, Lord.
When?
Let it be on 16th, Lordship.
9th of December,
Uh,
9th of December,
9th of December,
yes. Yes,
1811 it is fixed, Lordship, on the court below.
1812,
No, Lordship. Lordship, may kindly have a look at page number 133, Lordship, of my petition, Lordship. 1811 it is fixed below in the court below, Lordship. That is why I'm praying, Lordship, your Lordship.
for what?
For paying the arrear amount, Lordship. First installment of the arrear amount.
You file a application there that you have approached this court. 9/12,
That is why I was saying, so Lordship, may kindly make some observation regarding.
no, no observation.
I am deployed.
Next, please. It's a my lord revision against conviction, my lord, arising out of a my lord, NI Act case, my lord. My lord, trial court has convicted by 1 year and also my lord, impose a compensation of rupees 5 lakhs. Against that order, my lord, I have filed an appeal, my lord, and the appellated court, my lord, while setting aside the conviction of 1 year, my lord, was my lord, keeping the my lord compensation amount of rupees 5 lakhs intact. And thereafter, my lord, it was directed to pay 20%, my lord. Accordingly, I have paid 20%, and that was my lord collected by the present my lord opposite party. So this is my lord, notice.
No, why notice? On what ground? What is the error in the appellate court's judgment?
Here, my lord, finding of the court, your lordship will find it page 77.
On what ground you are challenging?
Lordship, my lord, from the very beginning, my lord, in the litigation, my lord, my stand was that, my lord,
Your sentence has been set aside. The
1 year
imprisonment,
sentence was set aside.
only compensation is, okay. Heard Mr. K. Borwa, learned counsel for the petitioner. This application under section 438/442 of BNSS has been filed by the petitioner, namely Nitish Ballabh Nath, impugning the judgment and order dated 1/8/2025 passed by the Court of Learned Additional Session Judge Golaghat in Criminal Appeal number 36/2024, whereby it has partly allowed the appeal preferred by the present petitioner against judgment and order dated 37/2024 passed by Learned Chief Judicial Magistrate Golaghat in CR within bracket NI case number 42/2023, whereby the sentence of imprisonment of 1 year imposed on the present petitioner by the trial court was set aside. However, the compensation of rupees 5 lakhs awarded to the respondent was kept as it is. Stop. Issue notice to the respondent. And call for the records of Criminal Appeal number 36/2024 from the Court of Learned Additional Session Judge Golaghat, as well as scanned copy of the records of CR within bracket NI case number 42/2023 from the Court of Learned Chief Judicial Magistrate Golaghat. The registry to take steps for requisitioning the aforesaid records. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days. Returnable after 4 weeks, list accordingly.
In the meantime, my lord, the trial court judgment has to be, my lord.
No,
stayed. I
let
have already
him,
deposited 20%.
let him appear.
Otherwise, my lord, on the next date fix, my lord, warrant has been issued, my lord, because my lord,
Warrant has not yet been issued.
till then, my lord, issued, but my lord,
No
I will-
urgency of giving an interim relief at this stage.
so, my lord, I have already deposited 20%, my lord, that is, my lord.
And that is where in the appellate court, that has been dismissed.
Lordship.
So let him appear.
My interim prayer may be, my lord, considered on returnable date, my lord.
The interim, the prayer regarding interim relief shall be considered after due service of notice on the respondent.
Ulai.
This is a revision application filed under section 438, 482 PNF against the impugn order dated 23/7/2025, passed by the Honorable Additional Session Judge Nagaon 2 in connection with criminal appeal number 60 of 2024. The impugn order has been passed by reversing the equitable judgment and order of trial court, which is passed by the Rane Trial Court on 5/11/2024 in connection with case number 64 of 2017.
Where is the error?
Milord, Rane Trial Court has passed the order is wherein there is no irregularities actually in passing the order, but the appellate court has passed the impugn order and reversed the trial court's order merit.
Heard Mr. K. T. What is your name?
Yes, Aman, Mr. Yes, Aman.
Heard Mr. A. Zaman, learned counsel for the petitioner. Also heard Mr. No, state is not a party.
It is a part of.
Yes.
Also heard Mr. P. Bhattakur, learned additional public prosecutor. This revision petition under section 438/442 of BNSS has been filed by the petitioner Shri Purandar Bora in impugning the order dated 23/7/2025 passed by the Court of Learned Additional Session Judge number 2 Nagaon in Criminal Appeal number 60/2024, whereby it reversed the trial court's judgment of acquittal of the present petitioner in NI case number 64/2024.
17, 64 of 17.
64 of 2017, and holding the present petitioner guilty of offense under section 138 of NI Act and sentencing him to pay a fine of rupees 8 lakhs and in default of payment of fine to undergo simple imprisonment for 2 years. Issue notice to the respondent number 2 and call for the records of the appellate court as well as trial court. The registry shall take steps for requisitioning the aforesaid records. The petitioner shall take steps for issuance of notice upon the respondent number 2 by registered by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
My lord, the The operation of the impugned order may kindly be suspended, my lord.
Are you
Because
ready
of-
to pay 20%? You deposit 20%, I will suspend it.
Lord, order has been already.
No, you answer my query or wait till the appearance of the respondent. Let the respondent appear.
Yeah.
List accordingly.
Unfortunately, a mistake has been happened. I'm so sorry to say, in title, cost title page number 3, actually it should have been 64 of 2017, but unfortunately for typical mistake, it appeared NI case number 72 of 20217. So, my lord, I may be kindly permitted to be.
Learned counsel for the petitioner
Corrected, yeah.
has submitted that an inadvertent typographical mistake has been crept in the cost title of the present revision petition and prays for rectifying the same. The prayer is allowed. The petitioner shall furnish the rectified cost title before the next date fixed.
Item 5.
Also, this is a civil contempt application.
Civil contempt.
Civil contempt,
Why before this bench?
I don't know.
This is wrongly listed.
Previously it was also listed before the criminal.
This court is not taking roster. Heard, Mr. What is your name?
M. Khan.
M. Khan, learned counsel for the petitioner. It appears that this case has been wrongly listed before this court. Registry to verify and list this matter before appropriate bench.
Is your lordship. Lordship, here lordship in this case, lordship, the informant who lost the affairs is the owner of a two-wheeler motorcycle. At the same time, lordship, petitioner number 1 wife is also a dealer of a motorcycle, but the inadvertently lordship, the said facts are not brought in the record. So may I pray before your lordship to take up this matter day after tomorrow? I want to file an additional affidavit bringing all these statements.
Heard, Miss T. Som, learned counsel for the petitioner, who submits that some relevant facts are not brought on records due to inadvertence, and therefore she prays for allowing the petitioner to file an additional affidavit, and also prays for adjourning the matter for today. The prayer is allowed. List this matter
Yes.
day after tomorrow. That is on 13th of November.
I'm deeply offended.
7.
May it please your lordship. Lordship, the washing application, my lord, under 528 BNSS, my lord, for washing off the charge sheet, the order of cognizance, and the impugned proceedings, my lord, before the learned SDJM Dollar. Lordship, primarily, the factual matrix in a nutshell is that the petitioner before your lordship happened to purchase one vehicle from the respondent number 2, my lord. Lordship would find that agreement at page number 37. The said transaction took place on the 13th of February in the year 2020, my lord. Dates are significant. So lordship, this vehicle was purchased by the petitioner from the respondent number 2. And subsequently, my lord, it is enshrined in the agreement itself that he would be paying, that the respondent number 2 would be paying the rest of the EMIs. And in due course, my lord, the vehicle RC, my lord, certificate of registration, would be transferred to the name of the petitioner, which, my lord, the respondent number 2 failed to do so after repeated requests, my lord. And my lord, ultimately, when the pressure was coming upon him, my lord, the respondent number 2, the respondent number 2 resorted the proceedings of the impugned FIR at page number 54, my lord.
Page number?
Page number 54, my lord, is the translated copy of the FIR, my lord. from which the impugned charge sheet stems up. This FIR, my lord, alleging that he had borrowed rupees 3 lakhs from the petitioner in the year 2017, my lord. This FIR is of the year 2024. In 2017, his FIR is that he borrowed rupees 3 lakhs from me, my lord. I did not go and offer. And my lord, the petitioner resorted to seeking interest of rupees 15,000 per month. And he has made a payment of 2,50,000 and this, that. And ultimately, my lord, when he failed to pay the amount of money, he has alleged that this vehicle, my lord, I had forced him to transfer to my name. So there is a notarized, duly notarized agreement, my lord, notary registration, register, signature and everything is present. So he has not sold, but I have forcefully entered into this agreement. It is what the statement is. So he is acknowledging the existence of this agreement, but however stating that I have forced him to enter. Page 54A, my lord, this FIR was registered under section 120B, 384, 387, 420 of IPC. This is important, my lord, for why, my lord, an uncontroverted ground is made in on my favor. Section 14, 20 and 21 of the Assam Microfinance Institutions Act, my lord.
What is this?
This is it. My lord, this primarily deals with, my lord, financial institutions. This statute, my lord, because, my lord, is difficult to locate, my lord, get the copy. So from the government website, my lord, it is downloaded. And my lord, for the convention proceedings, my lord, this statute is annexed as Annexure 11 at page 102, my lord. So, my lord, primarily, has my lord got it?
Yes.
My lord, page 102. My lord, Gazette notified on the 30th of January 2021, my lord. There's absolutely no mention in this specific statute that it would have any retrospective effect, my lord. And if we go by the uncontroverted version of the respondent number 2 itself, my lord, the money which was given to him was in the year 2017. The vehicle which was sold to me, my lord, was sold in the year 2020, my lord. Either of the transactions are prior to, my lord, this statute coming into force. Then, my lord, of course, with regard to this FIR, my lord, at that point of time in the year 2024, the petitioner was arrested. He was behind bars for a considerable period of time, then allowed on bail, my lord. And now, my lord, the impugned charge sheet has also been filed and cognizance has also been taken.
Under what provision?
Under, my lord, the cognizance, the charge sheet has been filed under section, lordship would find the impugned order at page number 77, my lord. Page number 77. The cognizance has been taken under section 120B, 384, 387, 420 of the Indian Penal Code, my lord. Read with section 14, 20 and 21 of the Assam Microfinance Institution Regulation of Money Lending Act 2020. Lordship would see the court which took the cognizance is the SDJM Dorong, my lord. The underneath signature and seal also is of the SDJM Dorong. And my lord, probably the learned trial court overlooked it. Even if we see that, consider that there would be some retrospective application of the Microfinance Act, my lord, the statute bars, my lord, apart from any fast track court to take cognizance, my lord. It's like a special act, my lord. In the Prevention of Corruption Act, like how it proceeds, the fast track court itself or the trial court, the special judge itself.
Which provision?
Lordship would come to the act, my lord. Lordship, first of primarily, my lord, there are 2-3 aspects because of which the Assam Microfinance Act would not be applicable against the petitioner in the instant proceedings, my lord. Firstly, my lord, at page number 103, 3.1, those are the definitions, my lord. So this defines.
No, okay, going by your submission.
My submission, my lord. My lord, section 14, my lord, clause 3, my lord. Section 14, this relates to the penal provision. This has been imposed upon me at page number 114, my lord.
So this Assam Microfinance Institution Regulation of Money Lending Act, this is not applicable.
Applicable primarily because it came into force subsequent to the
Because of it does not provide for retrospective effect.
their effect. And secondly, my lord, this
The
court, my
Court
lord,
is not competent court.
court is not competent court, my lord. Section 4, lordship may look into, my lord. Fast track court would be constituted and that court would be empowered and vested with the powers of the magistrate, my lord. No question of committing also, my lord. So because of the, my lord, statutory bar, my lord, and adhering to that being one of the parameters laid down in Bhajanlal, my lord.
But other provision pen IPC provision would be there.
Other provisions also there, my lord. For that, my lord, lordship, I take your lordship to the merits also, because my lord, I have also instituted, that is part of my pleadings, my lord. So at least if your lordship, my lord, most kindly allows me to issue the notice, my lord, and stays the proceeding because of the, my lord, statutory bar, or otherwise, my lordship, I can take you lordship through the other charge sheet as well, wherein, my lord, the investigating agency has clearly, my lord, notified that the vehicle which was notarized agreement, my lord, there was no force. It was duly and consensually done between both the parties, because I have also lodged an FIR, my lord, because I have come with clean hands, my lord. I have lodged, annexed that FIR as well, my lord. That lordship would find at page number 62, my lord. Immediately after, my lord, the end of my incarceration, after I came out, I lodged this FIR. This was also investigated upon by the same investigating agency, and the logical.
Yes, Mr.
Yes, my lord, your lordship has rightly pointed out, my page 77, charge not only framed under the, my lord, that is regulation of money lending, some microfinance institution act. There are also specific provisions of IPC, my lord. And those sections are in fact attracted, my lord, from the contents of the FIR. It seems that those provisions of IPC are attracted. So considering that aspect, my prayer before lordship at this.
Heard Mr. D.K. Buddha, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Prasanna Kumar Bora, praying for quashing of the proceedings of PRC case number 595/2024 arising out of Mongolde PS case number 59/2024 under section 120B/384/387/420 of Indian Penal Code, read with section 14/20/21 of Assam Microfinance Institutions within bracket Regulation Act. The gist of accusation in this case is that on when the FIR was lodged,
My lord, the impugned FIR first was lodged, my lord, on 14/2/21, my lord. My lord, give me just a moment. The received and registration date, my lord.
3/3/24.
3/3/24, my lord.
On 3/3/24, the respondent number 2, Shri Dipen Chandra Das, had lodged an FIR before the officer in charge of Mongolde police station, inter alia alleging that he took a loan of rupees 3 lakhs in the year 2017 from the present petitioner at an interest of 5% per month. And accordingly, he returned back some amount, that is rupees 1,50,000 to the present petitioner. Later on, by accumulation of interest, the principal amount and the interest became interest was demanded back by the present petitioner. The petitioner demanded rupees 3,40,000 from the informant. It is also alleged that thereafter the petitioner, by using various threats compel the informant to transfer his car bearing registration number AS01 DV 0913 in the name of the present petitioner. Stop. On receipt of the said FIR, the Mangaldai PS case number 59/2024 was registered under section 380 120B/384/387/420 IPC, read with section 14/20/21 of Assam Microfinance Institution Act. Learned counsel for the petitioner has submitted that thereafter, on completion of the investigation, charge sheet was laid against the present petitioner under aforementioned provision. And by order dated 19/12/2024, the Court of Learned Subdivisional Judicial Magistrate, Darong, took cognizance of offence both under the provisions of Indian Penal Code as well as also under section 14/20/21 of Assam Microfinance Institution within bracket Regulation of Money Lending bracket Close Act 2020. Learned counsel for the petitioner submits that bare perusal of the FIR would reveal that the allegation of money lending was made in the year money lending was in respect of the year 2017, and the car was sold by the respondent number 2 to the present petitioner in the year 2020, whereas the Assam Microfinance Institution within bracket Regulation of Money Lending Act 2020 was notified on 30 January 2021. Stop. He further submits that nowhere in the said act there is any provision regarding retrospective effect of the said act. Hence, he submits that the investigating agency erred in filing the charge sheet under this provision of said act, as well as the court of SDGM also erred in taking cognizance under the provision of the aforesaid act. He further submits that even if it is assumed, even otherwise, the said act provides that an offence under the Assam Microfinance Institution within bracket Regulation of Money Lending Act may be tried only by a fast track court. Which provision provides that?
Lordship would find it at section 14, clause 4, my lord.
Under section 14, clause 4 of the said act, whereas cognizance in this case has been taken by the court of learned SDGM Darong, which is in clear violation of the provisions of section 14 within bracket 4 of the said act. He further submits that otherwise also there are no materials justifying the filing of charge sheet under the provisions of IPC. Regarding IPC Act, we have to verify from the
Lordship,
uh,
just one line, if I may be permitted to point out, my lord.
yes.
My lord, his allegation is that, my lord, that I had forced, my lord, that there was force, my lord.
No, but 528 in exercise of powers under 528, we cannot go into those issues.
My lord, if uncontroverted documents are placed, my lord, yes, my lord, this is not a mini trial, my lord. I completely concur with this honorable
Yes.
court. That is why what I'm submitting, I'm strictly limiting, my lord, to whatever is there on record, my lord. So there's another FIR which was lodged by the petitioner, my lord, and the investigating agency, my lord, that is run by the same state authority, my lord. After, my lord, concluding the investigation, has clearly stated, my lord, lordship would find that charge sheet at page number 78, my lord. This is against the respondent number 2, wherein it is clearly stated that this notarized agreement, there's no coercion or not done by any fraudulent mean or forgery, but it was duly notarized before the notary. In fact, the notary lady, my lord, she happens to be a numbered witness in this charge sheet, my lord. Lordship would find her name at page number 82, my lord. At page number 83, my lord, she's listed witness number 8, my lord. And from the contents of this charge sheet, my lord, which I have also annexed, it transpires that, my lord, this was clearly sold by the respondent number 2, my lord. So me facing trial even under IPC, my lord, would also amount to abuse of process of law. And my lord, right now a civil case has also been filed with regard to the ownership of the vehicle. My lord, I have lodged a file before the competent court, my lord, in Dorong, my lord, civil court.
Learned counsel for the petitioner further submits that on perusal of the charge sheet, it clearly appears that the vehicle in question was sold to the wife
No, my lord, this is the charge sheet, not the impugned charge sheet, but the other charge sheet.
on the basis of your affair.
On the basis of my FIR, my lord, the investigations here concluded the investigation, and my lord has placed on record that the vehicle was duly sold by the respondent number.
What happened to charge sheet has been filed against the respondent number 2?
In that case also, my lord. So the FIR against me has also concluded in a charge sheet. The FIR which I have lodged against the respondent number 2.
In your affair, what you have alleged?
My FIR, my lord, that is the thing that, my lord, that falsely, my lord, I have been implicated in the case number 59 because I was pressurizing him to sell me the vehicle. And my lord, he had the initial intention to deceive me prior to entering into the agreement for sale. That is, my lord, he would take the money from me, and then subsequently he would, my lord, step away from transferring the vehicle into my name. That is why this charge sheet has been laid under section 420, my lord. Because he had the initial intent to deceive.
Stop. Learned counsel for the petitioner further submits that the present petitioner had also filed an FIR against respondent number 2.
That is at page number 62, my lord. Mongolway PS case number 245. Dated 7/9/24. The received and registered part is at page number 67, lordship.
What is the gist of this FIR?
Lordship contents, lordship would find at page number 64.
No, what actually you have alleged?
That lordship, the intention of the respondent number 2 and his wife from the outset was to, my lord, extract rupees 3,40,000 from me, enter into the agreement, and thereby refrain from transferring the vehicle into my name, my lord. That is the primary reason.
What is the last line? FIR against the respondent number 2 before the officer in charge of Mangalde Police Station on 24/8/2025, 24/8/2024, wherein he has alleged that the petitioner, that the respondent number 2, with an intention to deceive him, had taken loan of rupees 3 lakhs from him, and from the very beginning he was not willing to transfer the vehicle in the name of the present petitioner. He further submits that on the basis of the FIR lodged by the present petitioner, what is the police station case?
My lord, this is Mongoldoy Police Station case number 245 of 2024.
Mangalde Police Station case number 245/2024 was registered under section 420/34. And later on, charge sheet was also laid against the respondent number 2 and his wife,
Yes, my lord. Respondent number 2 and his wife. my lord.
2 and his wife. He further submits that the petitioner has also filed a civil suit
Before the, my lord, civil judge Dorong, my lord.
before the court of London. What is the civil suit number?
Lordship, that is title suit number 71 of 2025, my lord. Pending before the learned civil judge Junior Division Dorong, my lord.
Civil suit bearing
71.
title suit number 71/2024.
25, my lord.
2025, before the court of London, civil judge Junior Division Dorong,
Dorong, my lord.
seeking
Seeking,
What?
my lord, the ownership, my lord, ownership of the vehicle concerned.
claiming ownership of the vehicle. Stop. On the other hand, learned additional public prosecutor submits that even if the contentions raised by the petitioner in respect of Assam Microfinance Institution within bracket Regulation of Money Lending Act are accepted, still the allegations against him under the provisions of Indian Penal Code remains.
And my lord, question of deception will not arise because in the present affair, my lord informer in fact admitted that taking a consideration amount of rupees 3 lakh.
No, charge sheet has been laid.
Yes, charge sheet also, my lord, because he admitted that, my lord, by way of taking that amount, my lord, he sold the vehicle. to the-
He alleged that
Yes.
the respondent number 2 had deceived him.
Yes,
And on the basis of that allegation, an investigation was conducted in a
Yes.
different case and charge sheet was laid.
Stating that, my lord, there was a duly notarized agreement void
Okay.
of any my lord, coercion and deception.
Issue notice to respondent number 2, deputy, and call for the scan copy of the records of, what is the case number?
My lord, PRC case number 595,
PRC case number 595/2024, along with the scan copy of the connected case diary from the Court of London, Subdivisional Judicial Magistrate Dorong. Now, the registry to take steps for requisitioning the aforesaid scan copies. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 18th of December. So, any interim prayer
lordship, the proceedings, my lord, of PRC 595 may be stayed until returnable date.
considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs. Further proceedings of PRC case number 595/2024 pending before the Court of Learned Subdivisional Judicial Magistrate Dorong shall remain stayed till next returnable date. List accordingly.
Deeply obliged, my lord.
Please, your lordship. I, on behalf of my senior, I refer. My lord, as instructed by my senior that his petition is for quashing of FIR dated 01/08/2025, white paying Lata Seal PS case number 75/2025. My lord, here a complaint case was lodged by.
It is pending investigation.
Yes, my lord, FIR, my lord, file only on 1/8/25.
Oh, what are your grounds?
Here, my lord, a complaint was lodged by one Prasanda Pura, the chief.
We'll call for the case diary and issue notice.
Yes.
Heard, Mr.
Recently filed.
Compensation.
What is your name?
Compensation.
Naam likhiye. Learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner Mohammed Sohail, praying for quashing of the FIR dated 1/8/2025, filed by the respondent number 2, on the basis of which Lata Shil PS case number 75/2025 has been registered against the present petitioner under section 3 within bracket 3 of Passport within bracket Entry into India Act 2019-20, section 14 within bracket C and section 13 within bracket 1 of the Foreigners Act 1946, section 336 within bracket 3/340 within bracket 2/61 within bracket 2 within bracket capital A of BNS and section 12 within bracket small a of the Assam Money Lenders Act 2022. Issue notice to the respondent number 2 and call for the case diary of the aforesaid case. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable on 9th of this December. List accordingly.
On my lord, 27/11.
9,
Oh, yes.
9/12.
9/12.
May it please your lordship. My lord, here the petitioner is my lord, license holder for possession of my lord arms, my lord. His license, my lord, is at page 20, my lord. Original license that was seized by the police, my lord. And the type copy I have given, my lord. It starts from page 16. Page 20 is the, my lord, the origin photocopy from the original, my lord, Mokumuni Pura. Now, my lord, this license was, my lord, along with the arms, was seized by seizure memo, page 28, my lord, in connection with, my lord, Duliajan PS case number 317/2000.
Which
My lord,
judgment you are impugning?
yes, lordship, that initially I.
Impugn order is at
Page
page
36,
34.
my lord.
By
There, my
which?
lord, page 36 by the Court of Learned Sessions, this was filed under section, my lord, revision was filed under 397. There, my lord. Against the order of, my lord, learned SDGM, my lord. That order a page 34 was silence there, my lord. My lord, admittedly, it's a license was also seized, my lord, along with the pistol, my lord. So I have the, my lord, the permission to carry. Now, in the affair, my lord, there is no allegation. My lord, affair is at page 26. Use of, my lord, showing of this pistol at the place of occurrence. There is nothing, my lord. The accused persons, they were carrying 8 numbers of cows in a vehicle, and those, some boys stopped the vehicle and they have articulated this FIR saying that they demanded.
Heard Mr. B.K. Das, learned counsel for the petitioner. Also heard Mr. P. Thakur, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the present petitioner, filed by the petitioner, namely Mukumuni Bora alias Jagat, impugning the judgment dated 8/8/2025 passed by the Court of Learned Sessions Judge Dibrugarh in the criminal revision number 28 within bracket 3/2025, whereby it had upheld the order dated 23/6/2025 passed by the Court of Learned Judicial Magistrate First Class Dibrugarh in connection with Duliajan PS case number 317/2023, whereby the prayer for giving Jimma of the arms and ammunition as well as one arms license made by the present petitioner was rejected.
My lord, in case 40, my lord, just for a moment, para 8, my lord, prayer for cancellation of arm license of the accused has already been submitted. My lord, since the license is already there, they have, my lord, seized the license also. So I have a interim prayer, my lord. In the meantime, directing the IO not to proceed further with the cancellation proceeding, my lord. Since license is itself with them, my lord. So 25, 1A will not come, my lord. A person who is carrying arms without any license and the arms are with them, my lord. And the police has not seized it from the place of occurrence, my lord. The
No,
police,
we'll examine it,
my lord.
not now. The only state is the party, na?
My lord, yes.
Let the records of
Yes, there, my lord.
let the records of criminal revision number 28/28 within bracket 3/2025 be called for from the Court of Learned.
As well as, my lord, the case there.
Yes, Session Judge Dibrugarh, as well as the case diary
Duliajan
in
PS.
connection with Duliajan PS case number 317/2023 be called for. Case diary you have to produce. When? Let this case be listed on
9th of December.
9th of December.
My lord, page 13, my lord, interim, that's just a observation, my lord. Since lordship in season of the matter, the police should not proceed further with the cancellation of the license. my
No,
lord.
mere filing of a
Yes.
criminal petition would not.
My lord,
Let the
because-
case diary.
Because prima facie I have shown, my lord, that license as well as from where I have procure and the in the, my lord, yes. 25, my lord, kindly see, my lord.
Where is the provision for cancellation of license?
Yeah, cancellation to it in hand, my lord.
Hence, which provision is for cancellation of license?
Not this section edit as 25(1)A, my lord.
No, you
Yes.
answer my query.
Right.
Let the case diary arrive. We'll consider it on
My
the next day.
9.
List it on mine.
Application 9. Obliged.
May it please your lordship. Lordship, I have challenged this petition, I have challenged the order, lordship, that is on page 37, lordship. Here 311 petition has been dismissed by the trial court, lordship, on the ground that, lordship, it was file deleted, lordship.
Where is the impugn order?
That is on page 37, lordship. Operating part, lordship, page 40, bottom part, lordship. May I read that bottom part, lordship? Since the instance application seeking for recall of the witness have been moved at a stage when,
Why you want to recall them?
because, lordship, so the earlier, that is not my first plea, lordship, earlier advocate who has.
On that ground itself, it is liable
But
to
the
be.
material question is that also some question has not been put to the witness, lordship, which need to be put, lordship, the technical question which was not put, lordship. So
No,
may,
that cannot be a ground for
Because
recalling all the
because
witnesses.
lordship, may I take, lordship, the evidence, lordship, so far has taken, lordship.
No.
may-
Suppose we allow this time recalling.
Yes, lord.
You are again forget to put again question.
That's. why,
Again, you will
lordship,
come up with,
This is because, lordship, that is the only plea of this petition at that time, lordship. So if that opportunity allowed, lordship,
No.
if opportunity is not possible because we have to, lordship, since, lordship, its case was registered under a special act, lordship, it is burden on the, lordship, defense to, lordship, prove.
where is the error in the impugn order?
That is, lordship, page 40, lordship, bottom part, lordship. All the witness has not been, lordship, examined till that, lordship. Only 6 has been examined so far.
You want to cross-examine all 6
All 6, lordship.
after you have exercised your right to cross-examination.
Yes, lordship. but
How long
lordship-
you can continue this right of recalling
Lordship-
witnesses
Lordship,
and forgetting and again recalling witnesses?
lordship, 311 say, lordship, it can be, this application,
Unlimited.
because, lordship,
You
before
continue.
passing of the judgment, lordship, before pronouncing of
But
the judgment,
what are the grounds?
that, lordship, I have to establish, lordship, my case. I have to defense my case, lordship. Because that is the, lordship, burden on the, lordship, defense to prove that, lordship, that was not, lordship, recovered from this present petitioner, lordship.
How many witnesses are there?
8 witnesses, lordship.
Your lordship may kindly peruse page 38, my lord. In fact, there is not a single ground in this petition. This petition, in fact, is liable to be dismissed, my lord. Page 38.
That is the petition made before the court below.
Second,
lordship.
my lord, what ground they have made before the trial? court?
Page
Page 38, my lord.
30?
8.
30.
From second paragraph, my lord. Defense by the above application inter alia appears to submit that the earlier engaged learned advocate was unable to arrange for appropriate defense for the accused persons as they have been lodged in the judicial custody. It is further pressed that after the engagement of the learned counsel, afresh it unfolds that some pertinent questions material for the purpose of defense were left out, for which recalling PW 1 to PW 5 are necessary and hence the prayer. So, my lord, again, a new set of counsel will be engaged by the, my lord, accused person. Again, he will come by making the same prayer, my lord.
Because, lordship,
This cannot,
lordship, 315 is not over, lordship. Well, because I have to, lordship, that part was not over. Judgment is not pronounced, lordship. The opportunity may be given to recall and, lordship, to further examine the, cross-examine those person, lordship, which has not been put at that time, lordship. For that counsel, lordship, the
And even my lord, questions are
the
not also
petitioner should
specific.
not be suffered, lordship.
Questions are also not specific. Which are the question? my lord?
That question
want to put
cannot
the
be put at this
witness.
time because it will prejudice the defense, lordship.
Where is the error in the?
Because it's belated state. Say, lordship, on the bottom part, since the instant application for recalling, page 40, lordship, bottom part, lordship. May I read, lordship, that part? Since the instant application seeking for recall of the witness have been moved at the stage when almost witness of the prosecution were examined, cross-examined, and the discharge without pointing out the ground.
You read para number. Third last para in page 39. Page 39.
Yes, lordship. Upon the
Yes.
given fact and circumstances, it's appeared that the accused is trying to prolong the trial as the application in question in present case has been filed at the belated stage.
Next para, read next para.
It is also appeared that the application filed to point out exact nature of defense left out for the purpose of the court to determine the necessary and otherwise. It is also briefed of any explanation with regard to such delay. Because earlier counsel has not, lordship, put for that, lordship, the petitioner should not suffer loss. For the interest of justice, since judgment was not pronounced, lordship, other witness, lordship, PW, that is the other two witnesses are yet to be examined.
Yes, Mr. Bhattakur.
There is not a single ground. to
Yes.
interfere in the
This
petition line.
petition is dismissed.
Let the lordship can
No.
verify, lordship, they because
This
it was a
This
belated
petition
case,
is
lordship.
dismissed. I will pass orders in chamber.
Yes,
You go
lordship.
go to.
That peer, kindly record my submission because that.
I'll record everything.
Yes, lordship. Opportunity because it is burden on the defense to prove, lordship. It is not recovered from its concise position, lordship. That opportunity, lordship, has not been. Even though, lordship, it is in later stage. This application was filed in later stage, lordship.
Dismiss.
May I call, lordship, that the record may be verified. After that, lordship, found, lordship, no merit. Then
You fail to satisfy this court.
because, lordship, that things is, lordship.
I have already pronounced. You wait.
In this case, lordship, there are three petitioners, lordship. There is a mutual market took place between the petitioners and the informant family, lordship. Thereafter, petitioners filed an FIR, that is annexure 1, lordship, and the wife of the petitioner number 2 filed in this FIR, lordship. And subsequently, they also filed an FIR, lordship, that is annexure 2. That is Karimganj PS case number, lordship, 717 of 2022, page 21, lordship. Last paragraph.
You are praying for quashing of.
Lordship, in this case, what happened? We have applied for anticipatory bail and bail was granted to the petitioner's, lordship.
You are on bail.
Lordship, thereafter, charge sheet was submitted and we were shown as absconder and the learned trial court issued non-bailable warrant, lordship. Though we have applied for anticipatory bail before the court, lordship, those were rejected later on, lordship. So I am before your lordship, the order by which we were granted bail, that is annexure 7, lordship. Page 43.
No, what are you challenging here? The
Lordship,
entire proceeding or the order of
charge
issue?
sheet, lordship, the part of charge sheet which shows us absconder, lordship. As we, after obtaining the bail, we appeared before the IO and submitted our statements, lordship.
against
It is-
NBWM.
It is already
So
reflected.
basically you are against the
NBW, lordship.
NBW.
A chance may be given to face the trial, lordship.
Okay.
Of the
Where is your bail order?
lordship. Page 28, lordship, annexure 3. Order dated 24/5/2023, Lordship. Last paragraph, in view of the submission and material on record coupled with petition, the IO has failed to submit schedule since. So and so, the above named accused persons are allowed to go on interim anticipatory bail of so and so with a surety of the like amount to the satisfaction of the arresting authority. And
Later on, what happened to this interim bail?
later on, Lordship, the last portion, your Lordship will find this miss petition is thus disposed of. So accordingly, we appeared a progress report I have enclosed as annexure 4, page 30, Lordship. Page 31, last part, your Lordship will find during investigation, Lordship. The last, I have received an order copy of the Honorable Court dated 25/5/2023 regarding the accused persons, namely Abdul Hannan, Amiruddin, and Abdul Hasim, who are allowed to go on interim anticipatory bail with condition. And before charge sheet, Lordship 302 was added, we were never called by the investigating officer, Lordship. Our statements were recorded, we appeared according to the order of the learned trial court, Lordship. That as per order of the bail, Lordship. But we are shown as absconder in
Where is that portion where you have shown as absconder
Lordship.
in the charge sheet?
Charge sheet, annexure 6, page 35, Lordship. Page 40, paragraph 17, Lordship.
Where you are shown as absconder.
Lordship, during the investigation, the previous IO visited. Of this paragraph, last 2-3 lines. However, on the PM report, the death was due to cardiorespiratory fail due to massive pleural effusion and its impact. On 24/5/23, the accused persons were allowed pre-arrest bail, but accused persons were failed to comply with the court order of the Honorable Session Court. Karimganj did not appear before the police station. Investigation officer conduct house search, but all goes vain. But we have appeared before the Lordship IO and statements were recorded. It is reflected in the progress report, but in charge sheet, they have stated that we did not appear. And thereafter, we have filed bail application, pre-arrest bail application before the learned trial court, Lordship, that is annexure 7, page 43, that was rejected, Lordship. And thereafter, before the trial court, we filed our application to apprehending arrest that we may be arrested. Again, we filed application before the trial court. That was also rejected and NBW was issued, Lordship. Page 46.
What is page 30? The progress report submitted by the IO.
Progress report, Lordship. It reflects that we appeared before the IO during investigation, Lordship. Thereafter, we are never called, Lordship, by the IO. There was a mutual Marpet, Lordship. We have also filed an FIR.
No, where it is shown that you have appeared before IO.
Lordship, page 31.
31, yes.
During investigation, last part, Lordship.
I have received an order.
Yes, Lordship.
We
appeared and submitted our order, Lordship, before the IO, Lordship.
that is your submission,
Yes, Lordship.
but IO has not
IO in
acknowledged.
charge sheet stated that we did not appear, Lordship.
In the progress report also, he has not stated anything regarding your appearance. He has only stated regarding receipt of the order.
Lordship. Some protection may be given, Lordship. The case is pending before SDJM, Lordship. Not
What
yet
is the
committed.
offense?
302 was added later on, Lordship.
Although, my lord, during at the time of passing the interim order at page 29, although it maybe due to typographical my lord, mistake that was shown as disposed of, that fact was not later on not pointed out. My lord. and because of that.
It is the
Yes.
fault on the part of the court.
Heard Miss R. Chaudhary, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioners, namely Abdul Hannan, number 2 Amir Uddin, number 3 Abdul Hasim. Mainly aggrieved, the petitioners are mainly aggrieved with showing of their name in the charge sheet submitted in PRC case number 1675/2024 as absconder. And they are also aggrieved with the orders of the learned subdivisional judicial magistrate, whereby non-bailable warrant of arrest were issued against the petitioners. So, learned counsel for the petitioner has submitted that in the aforesaid case, during the pendency of the investigation, the petitioners were allowed to go on interim bail by the Court of Learned Additional Session Judge
In bail case. number
on
4.
24/5/2023 in bail application number 96/2023 by the Court of Additional Session Judge Karimganj. 2023. So she submits that in pursuant to the interim bail granted by the state court, the petitioners had approached before the trial court, before the investigating officer. However, in the charge sheet laid in connection with the aforesaid case, the investigating officer has stated that in spite of the grant of interim bail to the present petitioners, they failed to appear before the investigating officer, and therefore they were declared as absconder. Notice will have to go to the victim, because there is nothing to show that you actually appeared before the IO.
Lordship, the investigation says, Lordship, they have visited the house of the co-accused, Lordship. The progress report, your Lordship will find. Further, sir, during investigation, I have visited page 31. The house of complainant found available also examined some other witnesses and record their statements in connection with this case. I have conducted searches in the house of co-accused persons but found them not available in their houses and came to know that the accused persons are absconding police arrest in connection with the instant case. Further, I have also engaged sources and the DP personnel being asking them to inform me immediately if any kind of trace of accused can be achieved. The case is pending for arrest of co-accused persons.
Your Lordship may kindly peruse page 29.
No, but where is the indication that you have appeared before the
Yes.
IO?
They have not, categorically mentioned our names
Not
in
there.
first paragraph. But thereafter it is reflected that they were after the co-accused persons, lordship.
No, there may be co-accused other, but there is nothing to indicate that and that you have appeared.
Next date
Uh,
is 1911, lordship. That I have enclosed with the page 51, lordship.
You appear before the,
Some protection, lordship. Only I am seeking some protection. Bail may be
Actually,
granted
my lord,
to, as because SDJM is trial is pending.
protection in 528 case.
Lordship,
Only we can suspend the operation of
Lordship,
NBWA.
as soon as I appear, I will be taken into custody as because lordship, the case.
For,
Subdivisional SDJM case is pending and it was not yet committed, lordship. 302 was added. For that only seeking some protection.
otherwise, in fact,
but 528, you cannot be granted bail. Because specific provision is there.
yes.
Why inherent power may be exercised? When there are provisions for grant of bail.
That lordship, by suspension
Let
of
them, my lord,
the
appear.
orders, lordship. NBW may be suspended, lordship. I may be allowed to appear and my case may be considered.
No, you appear, that we can do.
Yes, my lord,
You appear, but bail will be considered by the trial court.
in
Not in
accordance with law.
accordance with law, lordship.
In violation,
Yeah, the lordship.
then you
SDJM,
can,
lordship.
then you have recourse.
Already bail granted to the
Saki,
petitioner.
क्या लिखा अंदर? Absconder. The petition, learned counsel for the petitioner submits that though the committal court has issued non-bailable warrant of arrest. Where is the order? Last order?
Page 51. Order dated 1/9/2025. NBWA issued against accused Abdul Hannan, Amiruddin, Abdul Hasim, lordship. All the three petitioners. And Jabrul Hussain is not before your lordship.
Has issued non-bailable warrant of arrest against the petitioners and fixed the next date of the said case on 19/11/2025. The petitioners are ready and willing to appear before the court on the said date. However, learned counsel for the petitioner prays for grant of some interim relief to the petitioners. Stop. After considering the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor, this court is, since the petitioners are willing to appear before the court and to cooperate in the trial, hence this criminal petition is disposed of with an observation, with a direction to the above named petitioners to appear before the trial court, appear before the court of learned SDJM S. Shri Bhumi on the next date fixed in PRC case number 1675/2024, that is on 19/11/2025, and to facilitate their appearance before the trial court, the operation of non-bailable warrant of arrest issued against them shall be kept in abeyance till that date. Stop. On their appearance before the said court, the petitioner may seek any relief to which they are legally entitled to. This,
They are already taking protection, their case may be considered, lordship.
no, that you have to make submissions before the trial court. You have to convince the trial court.
Lordship 302 was there, this is not the trial court, not yet committed. Maybe this court has no
Then you
power to
have to
grant bail.
seek, then you have to seek relief, appropriate relief.
Lordship. Obliged.
Right, please, your lordship. Lordship, here, my lord, we have filed this petition for quashing the proceeding. My lord, here petitioner number one is the accused person. Petitioner number two is the victim. She is after subsequently married. Now she is living a family life with a child, my lord. Now due to this proceeding, my lord, her family life is in dangerous condition, my lord. Anything is including her child also, my lord. So the victim came up with this petition and FIR, my lord, the father of the victim lost FIR saying that on 18/7/17, the accused petitioner number one took her girl to his house and restrained her and suspected he raped her. That was the case, my lord. Thereafter, my lord, on 18/7/17 FIR was lost. Thereafter, very immediately, my lord, page 25, the father of the petitioner, a bit of compromise, my lord, had been made, saying that due to mistake, my lord, he has lost the FIR. That is
Father has also,
Father also subsequently now victim also says, page 25, last paragraph, my lord. The father says that my lord, immediately after lodging FIR, within a month, my lord, says that it was mistake, my lord. Then charge sheet was framed. Now, my lord, the victim also, that is page 33, 11 portion page 34, my lord. Paragraph 3, victim also saying that, may I read, my lord? Page 34, paragraph 3, that presently I am married to one so and so, and I am living very, very happy and peaceful married life with my husband, along with my side, namely so and so, of 4 years. Due to aforesaid I have been facing mental agony with my husband, child, as if the proceeding of so and so case arising of so and so is pending before the honorable so and thus Mankasar is continued. My peaceful married life will be disturbed, my lord, harmed and ruined.
okay,
And therefore, if
yes, Mr.
My lord, in this case, although my lord, now he has submitted all these things that both parties has compromised regarding the POSCO, my lord, they will have, well, I will have to go through the record when the marriage was solemn after, my lord, because allegations are serious. My lord, 164 statement of the victim, and my lord, when my lord, whether my lord, they will have also have to file additional affidavit by the victim, my lord. Only, my lord, he appeared.
Your father or wife?
Father, that's for number 2, lord.
victim is petitioner number 2. Victim is here, my lord. before my
And
lord.
now under case is registered in the year 2017, my lord.
My lord, in this
Okay.
state, my lord, may I-
Heard Mr. M.R. Kondokar, learned counsel for the
second,
petitioner.
before my lord. My lord, in
No, wait,
And this is, there is
Kopil
no,
Gupta, my lord.
well, there is no, my lord, sections of child marriage
In
act is
Kopil
also there,
Gupta,
my
my
lord.
lord. Kopil Gupta.
we'll call for the records.
Yes, ma'am. Right,
Till
right.
then, my lord, because the life of the child and the victim, my lord, and their family time, my lord, married life will be going to be ruined.
Heard Mr. M.R. Kondokar, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional public prosecutor, as well as Mr. R. Islam, R. Hawk, appearing for respondent number 2. This application under section 528 of BNSS 2023 has been filed by the petitioners, namely Samirul Islam, who is the accused in special P case number 181/2024, as well as the petitioner number 2, who is the victim of the said case. Praying for quashing of the proceeding of special P case number 181/2024. Stop. Learned counsel for the petitioner, where is the FIR?
FIR, my lord, page 20.
Learned counsel for the petitioners has submitted that the on the basis of an FIR lodged by the respondent number 2 before the officer in charge of Mankasar Police Station, interiorly alleging that the petitioner number 1 on 26/6/2017 forcefully entered into the house of the complainant and by taking advantage of the absence of other family members, took away the minor daughter of the informant with him. On the basis of the said FIR, Mankasar PS case number 588/2017 was registered under section 366A/376/511/34 of the IPC, read with section 10 of the POCSO Act 2012. Later on, charge sheet was laid in the aforesaid case. Mr. Debarshi Kumar Bhattacharya is appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish the copy of bail application along with annexures to the newly appointed amicus curiae within two days from the date of this order. List this matter again. On 21st of November.
21st of November.
Item 16.
That is all. The FSL report has not been listed, my lord. In the last two occasions, my lord, that have been.
FSL report is necessary or not?
Because to know the parenting, my lord, about the child. that has been
You are on interim bail.
No,
No, no.
no, my lord.
No.
This is regular. bail
Charge
application.
sheeted case, my lord. That's in the kind of last order, my lord.
What is the case?
Also, my lord. 6.
Why FSL is required?
Because a baby has been born, my lord.
So regarding
DNA
paternity,
DNA
Yes,
report.
paternity,
Yes, paternity.
okay. Heard Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. D. K. Agarwala, appearing for respondent number 2. It appears from order dated 23/10/2025 that the eh, eh, the additional public prosecutor was requested to produce the FSL report. However, same
My lord,
has,
here I have also on submission, my lord, as it is already submitted charge sheet, my lord. Whether it is.
charge sheet submitted,
My lord, here charge sheet
Yes,
submitted,
then
my lord,
whether
receiving,
FSL report is the,
my lord.
whether any forensic examination has been conducted or not.
That,
Then from where FSL report will come,
that has been conducted, I think, my lord, because on the last occasion, my lord. there is
then
an
that
order, my
will
lord,
be in the case diary.
for testing of the DNA test, my lord. Then the last, on 2 occasions, my lord.
You have gone through the case diary.
Not, my lord.
Go through the records. Whether any forensic examination report or DNA test has been conducted or not,
Each section, it hasn't been conducted.
not conducted, then from where we will get FSL report? If we go on giving dates for FSL report, if some examination has not yet been done, from where we will get reports? So we will hear this matter without FSL report.
Thursday then, ma'am. We'll go to the
Stop.
record, my lord.
Though it is reflected in the earlier orders that FSL report has been called for as regards the DNA test. Which was allowed by the which was allowed for establishing the paternity of the child born out of the alleged sexual intercourse, however, the learned counsel for the petitioner as well as learned additional public prosecutor are unable to inform this court as to whether any such direction was given by the you submitted that you had submitted on the last date that FSL was allowed by the trial court.
Yes, my lord.
Verify from the record.
Next, let's see, my lord, page 19, my lord. Blood sample has already been collected, my lord.
Page,
Page 19, my lord, and next, let's see.
what is your name?
S. Soikia, appearing for N. Hassan. in the report.
Heard Mr. S. Soikia, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned
Right.
additional public prosecutor. On perusal of the office note dated 22/10/2025, it appears that notice to respondent number 2 has been served, duly served. Stop. However, no one has appeared on behalf of respondent number 2. amicus solitio. Therefore, this court is inclined to appoint an amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Srimati Priyanki Das, whose name appears in the list of amicus curiae prepared by the registry, is appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish a copy of bail application along with annexures to the newly appointed amicus. Registry is directed to reflect the name of Ms. Priyanki Das as amicus in this amicus curiae in the cause list henceforth. List this matter on 26th November.
So let's say for item 18, I'm bringing for an example. Lordship, item number 17 and 18 both are of the same petitioner. So same date may be fixed for. In this matter, Lordship, I have filed my Bakalan number on behalf of respondent number 2.
Okay. Heard Mr.
S. Saikya.
S. Saikya, learned counsel for the petitioner. Also Mr. B. Sharma, learned additional public prosecutor, as well as Mr. A. Ganguly, appearing for respondent number 2. Learned counsel for the petitioner has sought for an adjournment. Why you are seeking adjournment?
The English counsel is not well for today. That's why.
On the ground of personal difficulty of the engaged counsel for the petitioner. Considering the ground, the prayer is allowed. Let this matter be listed again on 26th November. Same day, that is 26th November.
Okay.
Yes.
19. My lord, as per office note, my lord, 1510, my lord, service report awaited, my lord.
Boxometer.
Boxometer.
You find out,
The step your on.
you find out from the IO.
My lord.
Heard Mr. M. Ahmed.
SEM.
What is your name?
SEM.
Heard Mr. S.D.M. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the service report in respect of notice issued to respondent number 2 is still awaited. Stop. In view of the aforesaid submission, learned additional public prosecutor is requested to take information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station and let this court know about the same on the next date fix. Let this matter be listed on 24th. A short date may be given.
Yes.
18th of November.
Hello.
20th, 21.
Please, your lordship. Lordship, I am for the 21 item. My lord, kindly taken up the 21 item number 21. My lord, in this case, my lord, search sheet has been given. My lord, allegation is very much serious. My lord, no doubt, my lord. Here, my lord, a couple of accused has been arrested, my lord. And lordship will find. Lordship allegation. Lordship will find allegation at page 11, my lord. This is the translated type copy, my lord, and original also I have annexed. On the date of the lodging the FIR, my lord, he was injured, but later on he was died and that section for the murder was incorporated. And after lodging the FIR, my lord, the case has been registered. And case has been registered, and then, my lord, the 11 persons were arrested, my lord. Lordship will find the forwarding at page 15, annexure 2, my lord. This is the important, my lord. Already been searched, my lord. page 15, my lord. I
Where,
am
where
reading
is the FIR?
FIR from FIR earlier, my lord, that is at page 11, my lord. May I read the thing?
Okay, thereafter,
Thereafter, my lord, 11 persons were arrested, my lord, in the very next day, my lord. And they, accordingly, my lord, on 23rd of April, they were produced before the CGM court. And my lord, kindly see the forwarding report, my lord. The first paragraph, my lord. With reference to the subject cited above, I have the honor to forward here with the below noted accused person arrested in connection with the above referred case with a pair to grant police remand for a period of 5 days of accused person, namely Abdul Nur Rizu and Ruhit Rajput. They were remanded for the police remand, my lord. Here the petitioner is the Mon Borua, my lord. In that Mon Borua, my lord, the paid before the honorable court to send the accused Babu Ali, Arsojit Borua, Jangpu, Debojit Borua, Vikas Chetri, Ramzan Khan, Abdul Rahman, and Maina, Mon Borua, Pranab Goswami, so and so, judicial custody. From the very beginning, my lord, they are in judicial custody. Police did not remanded them, my lord. And my lord, kindly turn to page 18. Police never remanded the present petitioner, my lord. What happened, my lord? The name, two name, my lord, in the forwarding lordship may find the name of the Abdul Nur Rizu and Ruhit Rajput. They were the prime accused, my lord. And we are the only accompanied with the prime accused and we present in the collusion, my lord. For that, the resulted the victim was died, my lord. And my lord, already, my lord, 204 days on today. And thereafter, my lord, the police has submitted the search sheet. And search sheet has submitted on 19/6/2025, my lord. Lordship will find that search sheet started from page 19 and except 3, my lord. And in the search sheet, my lord, there were no specific allegation against the petitioner, present petitioner, my lord, but allegation is mainly,
it is a case of mob lynching,
yes,
mob lynching.
yes.
Not exactly mob lynching, but my lord, as because my lord, they are in a, my lord, that is the Bihu festival program, my lord. At that point of time, my lord, there's a quarrel, my lord, took place, and these people, my lord, the group, my lord, group of people who went there,
Assaulted.
my lord, very badly because my lord, the person died, my lord, and they want to go for to rescue the persons. The others, those independent witnesses are there. When they came and found that already he is not died, but he's with bloodsets and all, he's lying, the person, and immediately admitted to the Jorhat Medical College Hospital. Later part, my lord, this case, my lord, because my lord, there's a group of people was a TIP prayer was made and TIP was conducted. Now the present petitioner, my lord, during the course of TIP, he was identified by the, my lord, that is the independent witness, my lord. Present, my lord, in this case, my lord, Mon Borua. Mon Borua is identified, my lord.
And all were identified, my lord, not only Mon Borua, my lord.
And
all
my
were
lord, from the,
identified
my lord, that is
from the forwarding and the search sheet.
Where is the rejection order of the trial?
Lordship will find at page 38, my lord. Started from 38. The relevant portion Lordship will find at page 40. That was passed on 8 August 2025.
When the charge sheet was filed?
The search sheet was filed on 19/6/2025. Already, my lord, the case has been transferred to the additional CGM session judge Jorhat, my lord, for trial, and trial is almost about to be started, my lord. At this stage, my lord, already they were there in the present petitioner, both the petitioner, they were not the prime accused, my lord, they were accompanied. It is true, my lord, they were all identified the eyewitnesses because they were present in that particular collusion, my lord. But the intention only on Rizu, only the police has remanded only that person.
Mere police remand does not shift.
No, actually, that is true, my lord. That is true, my lord. But already, my lord, the search sheet has been submitted, my lord, case is going to be started, my lord. And there is nothing to be, all, my lord, as per from the searches, it is revealed that the statement has been recorded, all the evidence has been saved, my lord, produced before the court. There is no any possibility to hamper or temper any evidence, my lord. Nothing has been done, my lord, because all has already been before your lordship, before the trial court, my lord. Therefore, my lord, as this is, my lord, since they were not the prime accused, already they have spent 204 days on today. They may be gone bail,
You
my lord.
Find out what are their specific rules.
My lord, here, my lord, that is, date of incident was, my lord, 28/7/2025. No, my lord, that is,
No, have you gone through the specific roles?
specific rule is there, my lord, their involvements is there, my lord. My lord, 183 statement of the independent witness, my lord, who, my lord, during the course of, my lord, TIP, my lord, identified, my lord. So they showed that, my lord, that the person was beaten by these people, my lord. And, my lord, the PM report, my lord, is also there, my lord. So now, my lord, the case is, my lord, in the trial is, my lord, progressing. It has already been commenced, my lord. Charges has already been framed, my lord. Now it is the stage of evidence, my lord. And, my lord, that is the first date, my lord, was 24/9/2025 for evidence. And the next date is fixed, my lord, 22/10/2025. At least, my lord, those independent witnesses, my lord, those are the material witnesses, my lord, the present, my lord. The three persons, my lord, those were the.
How many witnesses?
My lord, total there are, my lord, PWs are, my lord.
No, you point out who have named them.
My lord.
Those witnesses have to be identified,
Yes,
examined.
My lord, here, my lord, in case of, my lord, Mon Borua, my lord, the one witnesses, my lord, is needed to be, my lord, examined, my lord. That is, my lord, one witness, my lord.
After examination of the witness who has identified him.
My lord.
My lord, already charge has been framed, my lord.
No. The
Because, my lord, there was no any possibility because he is in another side, my lord. And already in jail, my lord, there is no any possibility because already 204 days has gone. And, my lord, charge has been framed. And only one witness, his witness has, his statement has been recorded. And his, another thing has been seized. No, nothing has been done with Mon Borua, my lord. He is not the prime accused also. He also, or he is not the.
No, where is the rejection order of the trial court?
Lordship will find at Annex of 4, page 38. That order was passed on 8/8/2025.
Page
38, Annex of 4.
38 is it, trial is pending before this court?
Yes, additional session, Judge.
Let the independent witness be examined. Heard.
23 numbers of PWs are there, my lord.
How many independent witnesses are?
My lord, independent witnesses
good
are there,
independent,
but for the case of, my lord, Mon Borua, because he is identified by one, my lord.
Who has identified?
My lord, that is, my lord, Ranjit Datta, my lord.
Heard, Mr. D. Borua, learned counsel for the petitioner. Also heard Mr. A. Bushra, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Shri Man Borua alias Mon Borua, who has been detained behind the bars since 22/4/2025 within bracket for last 204 days in connection with what is the sessions case number?
2/, session case number 84/25.
in connection with sessions case number 84/2025 under section
One 126/2,
126/2
1182,
slash 1182 slash
1091,
1091
35,
/3 within bracket 5.
191/2, 191/3, 190, 3031 of BNSS.
Stop. The gist of acquisition in this case is that on 21/4/2025, one Bhuvan Chandra Bora had lodged an FIR before the officer in charge of Lichubari Police Outpost under Jorat Police Station. Jorat Police Station, inter alia alleging that
April 11.
on the 9th of 20 April 2025, the son of the informant was assaulted with sharp objects by one Riju, and some other associates. Causing grievous injury on the person of the son of the informant. Later on, the injured person succumbed to his injuries. Stop. Learned counsel for the petitioner has submitted that the petitioner is languishing behind the bars for last 204 days, and as the charge sheet has already been laid and the petitioner is ready to cooperate in trial, his custodial detention may not be necessary for fair completion of the investigation. He further submits that even during investigation period, at the time of production, their production before the court of London, before the remand magistrate, the police did not prayed for police remand of the present petitioner, and he was only remanded to judicial custody. Learned counsel for the petitioner further submits that this indicates that the petitioner is not the main accused of the offense alleged in the FIR. He further submits that though petitioner was present at the spot, he did not participate in the alleged offense. Stop. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner at this stage. He submits that the offense involved in this case is of serious nature, where the victim was brutally assaulted, which led to his death by the accused persons, brutally assaulted by the accused persons, which led to his death. He further submits that the petitioner has been identified as one of the accused during the test identification period by the independent witnesses. He also submits that one of the witness, namely Ranjit Datta, had specifically witnessed the petitioner assaulting the victim, and therefore, unless the said independent witness is examined, if the petitioner is allowed to go on bail at this stage, there is likelihood of influencing the said witness by the present petitioner, and hence he prays for rejecting the prayer for bail at this stage. I have considered the submit. We are rejecting your prayer. Let the independent witness be examined. I have considered the submissions made by learned counsel for both sides and have gone through the scan copy. Is there with you?
Yes, my lord, the scan copy, I have all the relevant parts, my lord, I have flag marked, my lord.
Gone
from
through the
183
scan
and
copy of
everything, my
the
lord.
records. There are sufficient incriminating materials against the present petitioner in the records. Further, considering the nature of offense involved in this case, this court is of considered opinion that it may not be appropriate to grant bail to the present petitioner before examination of the witness who had implicated him in this case. Hence, the prayer for bail is rejected at this stage.
At this stage, Lordship.
At this stage.
Lordship, item number 20, Lordship. May I submit, Lordship?
Yes.
Page number 37, Lordship. While TRP done, Lordship, independent witness is there 3, Lordship. But petitioner was not identified by the 3 independent witness, Lordship. Paragraph number 8, Lordship, page number 37. May I read, Lordship?
How many petitioners are there?
Only one, Lordship, Ashwajit Borua.
Ashwajit.
His name is not FIR, Lordship.
Then
and
why
also-
you were arrested on,
Arrested, Lordship, behind the bar, Lordship.
since when?
Same day, Lordship, same day.
204 days. Oh.
My lord, here, my lord, TIP, I have gone through the same, my lord. My lord, two times the TIP was done, my lord. One, my lord, that is the TIP for the my lord Mon Borua was identified earlier occasion, and the present petitioner, that time he was not identified, my lord, at that stage, my lord. That, before that, my lord, another TIP was again, my lord, conducted, but not for my lord, that is the present petitioner, my lord. But now, my lord, the thing is that, my lord, this TIP was done for, my lord, that is the present petitioner, and the earlier one, Mon Borua, on, my lord, that is 5/6/2025, my lord. Prayer they have made on 2/6/2025, and the TIP dated 5/6/2025. My lord, here in the record, my lord, which is available before this honorable court, my lord, we have, my lord, the statements of all the co-accused from different co-accused, from where it is clear that during the, my lord, that is the quarrel, my lord, he was also very much present, my lord. But, my lord, regarding the entry of the CD, why, my lord, he was on the basis of whether on the, that is the basis of the co-accused statement, he was arrested, or that part is not, my lord, clear, my lord. Because from, my lord, that is the 5/6/2025, the entry from the side of the IO is not available, my lord. But, my lord, search sheet is available, my lord. In the search sheet, my lord, regarding that part, my lord. In the search sheet, my lord, it is stated, because why, my lord, we are submitting. My lord, during investigation, the statements of the witness, video footage of the incident, post-mortem report, TIP and the statement of the accused person revealed that 24/2025, there was a Bihu function at Chandannagar Janapad, and victim Bedanga Bhushan Borua had come to watch the Bihu function with his friends. At that Bihu function, some quarrel occurred between the accused person and the victim Bedanga Borua. During investigation, it came to light the arrested accused person, Abdul Nur Riju, Babu Ali, Osojit Borua, alias Zanku, Devojit Borua, and others' names are also there. Physically assaulted the victim Bedanga Borua with an intention to kill him and fled away from the spot. There was witnesses of Ranjit Datta, Mayur Datta, Jugal Kishore Datta.
No, whether these witnesses have named him.
In the TIP, my lord, they didn't.
Otherwise, whether they have named him.
He has named from the other co-accused, my lord, because they have
No,
stated
apart
that-
from co-accused.
apart from co-accused, because my lord, but in the TIP, my lord, he was not, my lord. I didn't
No,
notice.
my query is
My-
not only TIP.
My lord,
Is there any other witness
my lord,
during his 180 statement
my lord,
have implicated him or not? If nobody has implicated him,
my lord.
then he cannot be detained.
Yes, my lord, that part. Then, my lord, I pray for some more time, my lord.
We will
Because, my lord,
at-
183, I gone through that, my lord, because these three witnesses, my lord, they are not implicating those who are in the part of the TIP.
Wait,
Rest
how
part-
much time? At 2,
My lord, at 2,
At
because
2
it is
PM.
voluminous at 2, my lord.
at
I
2
will again
we
give a
will,
look.
we'll
Yeah.
take it up.
Yes. How like it?
Good afternoon, sir. Sir, I'm the petitioner in person for item number 42 for today, sir. If the chances are bleak, sir, some other date can be given, sir, and time also.
Okay,
14th of November, sir.
14, instead of 14th, let it be in the next week.
Okay, sir.
You choose a date.
17th or 18th, sir.
Item number?
42 of for today, sir.
What is your name?
My name is Dr. N. Rajamartandan IPS, sir. Presently, I'm serving as Senior Superintendent of Police FRO Barpata. I'm
Heard,
getting,
Dr.
yes, sir.
Rajamathadan, the petitioner in person. Also heard Mr. K. Bashir, learned additional public prosecutor. As there is a bleak possibility of this matter being taken up for hearing due to paucity of time, the petitioner is in person prays for fixing it, this matter on 18th of November. The prayer is allowed, list
Thank you, sir.
accordingly.
The time may be, if possible.
Time 10:30. At 2. On 18th at 2.
Thank you very much.
You have informed,
For the petitioner, my lord.
heard Mr. D. Bora, learned counsel for the petitioner. Also Miss M. Deka, learned additional public. Day after tomorrow, Friday, it may be difficult. Let it be in the next week. On request of learned counsel for the petition. Learned counsel for NCB. When? Learned counsel for NCB. Let this matter be listed on
17, my lord.
18th of November.
Obliged.
Lordship, TIP equal lordship page number 37
He could not be identified.
could not be identified.
Anything else? Anything specific against the?
In any statement, other independent witness, My lord, there are 23 number of PWs, my lord. And among 23 number of PWs, my lord, the witnesses, the independent witnesses are, my lord, that is 7, my lord, witnesses are there. 3, I have already done, my lord, 183 statement. Those who are in the part of the PIP, my lord, they did not, my lord. My lord, indicate which
Some more PWs have.
just completed. Only that part because.
Or we take it up tomorrow or day after tomorrow. Heard Mr. K.R. Bora, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor, who submits that he may be granted some more time to go through the case diary to find out whether any implicating materials have been specifically stated against the present petitioner by any of the witnesses who have been examined during the course of investigation. The prayer is allowed. Let this matter be listed day after tomorrow. That is on 13th of November. Tomorrow, 12th of November.
Highly available. Item 44. Finding item 44.
May I please your lordship?
Yes.
This, by way of this petition, your lordship, we have put to challenge an order passed in your lordship criminal defamation complaint, your lordship. Impugn order, your lordship will get it at page 50. 50 is the 43 is the first order issuing notice under 223 section. And the final order, your lordship, at page 50, your lordship. Now essentially, your lordship, the facts is like this, your lordship. Complaint was filed, your lordship, alleging defamation, your lordship, by order dated 15/2/2025 at page 43. Notice was issued, your lordship. Now, before issuance of the notice, your lordship will kindly come to page 43.
Yes.
Complaint so and so is represented by his counsel, heard peruse the case record. I have
You are
also-
for Manoj Chauhan.
Manoj Chauhan. I have also perused the relevant material placed before this court. The present case has been filed under section so and so and so and so. Section 220 of BNSS states a magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by complainant and the witnesses and also by the magistrate. The first proviso.
Where are you reading?
Lordship, page 43.
Yes.
Second paragraph, your lords, third paragraph. The first proviso of this eighth section states that no cognizance of
In
an
page 43,
Yeah.
that is the brief written argument only.
No, your lordship, is
Pagination may be.
yes. It starts from page 44, your lordship, the written something, just before that page, your lords,
Page 44, 43,
lords.
it is the written argument.
Then 42, your lordship.
42 is order dated
Lordship, that is.
15
to. That is why I'm reading.
15 Yes.
Complainant so and so is represented by his learned counsel so and so, had perused the case record. I have also perused all the relevant materials placed before the court. The present case has been filed under section 363536 of BNS. Section 223 of BNS states that a magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. The first proviso of this eighth section states that no cognizance of an offence shall be taken by the magistrate without giving the accused of an opportunity of being heard, according to this court deemed fits where hear the accused persons before taking cognizance of the present matter, and then your lordship notice was issued, your lordship. Now, your lordship, we appeared, your lordship, by filing our Wakalatnama, your lordship. Our specific plea before the learned court below was, your lordship, that without your lordship examining the complainant, your lordship, the notice could not have been issued, your lordship. First, your lordship, as per the mandate of 223, your lordship, along with the complaint, your lordship, complainant and other witnesses, if any, would have to be examined, then notice will have to be issued. And your lordship, thereafter, your lordship, after hearing the parties and taking note of those materials, your lordship, court will take cognizance and pass and issue summons, your lordship. That is, your lordship, that is gist of our argument before by way of this written argument we have submitted before the honorable court below, your lordship. And we have relied on few judgments also. And finally, this on the learned court below pass order, your lordship, dated 27/10/2025, that will be page 49, your lordship. 50.
No, you filed some objection.
Lordship, after objection, that was, your lordship.
You filed a petition before the trial court.
No, we filed since it's a written, your lordship, only
Yes,
for
your
argument.
plea
Our plea, we have
that-
argued that since
that even the notice under proviso to 2020, 223 cannot be issued.
it should be issued without examining the complainant.
Okay, you have some authorities.
Yes, I have some authority.
Then what order was passed?
Your lordship will get it at your lordship, ordered at 27/2/2025, the last annex, your lordship, will be probably
Page
page
number,
49, your lordship.
please read it.
Your lordship got it? Right.
Yes.
Complainant is absent and filed petition number.
You read the relevant portion.
Lordship. Your lordship will kindly come to next page, your lordship. The finding of the court, your lordship, will get. Section 223 of BNSS states that examination of the complaint, then your lordship, that's the provision stipulates that.
Yes.
After hearing both sides, the most significant question that needs to be addressed in this case found to be as to what does the word cognizance connotes, and also at what stage the point of time it could be said that cognizance has been taken by the court. In a legal context, by various judicial pronouncements, cognizance refers to a court or magistrate with jurisdiction taking judicial notice of a case matter to determine if there is sufficient basis to proceed judicially in the language of Honorable Apex Court employed in RR Chari versus State of UP, AR so and so. Taking cognizance does not involve any formal action or indeed action of any kind, but occurs as soon as a magistrate as such applies his mind to the suspected commission of offense. After going through the provision of section 223 of BNSS, the addition of while before taking cognizance appears to me that it suggests that court is now in the process of taking cognizance, implying the cognizance has not yet been taken. It appears that said provision introduces an intermediate stage between filing and registration of the complaint and the recording of statements. It is at this stage that issuing notice to the proposed accused seems to be the legal requirement as mandated under section 223 of BNSS. In view of the above discussion and meaning of term cognizance by the Honorable Apex Court, I incline not to refer to judgment passed by the Honorable High Court relied on by the proposed accused persons while passing the order. The other judgments so and so is with regard to applicability of section 202 of CRPC at this stage of section 202 of CRPC, section 225 of BNS is yet to arrive, and this case and hence found to be of no help to the proposed accused person. The result above discussion after hearing the sides, I deem it fit to proceed further with the case examination of the complaint. Now, your lordship, we are aggrieved by this, your lordship. Our case precisely is this, your lordship. If your lordship looks at the 223 for a moment, your lordship.
Yes. Yes.
a magistrate having jurisdiction while taking cognizance of an offence on a complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. Provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard, your lordship. Then, your lordship, next, we are concerned with this proviso, your lordship. Now, your lordship, this apparently, this made clear that there is no as has been postulated by the learned court below, your lordship, learned trial court, your lordship, there cannot be 3 stages, your lordship. There will be 2 stages, your lordship. Registration of the complaint and thereafter, your lordship, examination of the complainant and any witness if there, and thereafter, your lordship, notice will have to be issued to the proposed accused persons, your lordship, after hearing the parties, your lordship. And then, your lordship, also taking account of the materials placed before the learned trial court, your lordship, then cognizance will have to be taken, or your lordship, the learned court, the trial court will dismiss the petition. That's what, your lordship, our plea before the honorable learned trial court as well as, your lordship, this honorable court, your lordship. Now, your lordship, when 202, this is, your lordship, in BNSS, your lordship, this is for the first time, your lordship, this stage has been, your lordship, introduced, where, your lordship, before, your lordship, taking cognizance, the persons are required to be heard, your lordship. Now, it will be an empty formality if, your lordship, the complainant, the proposed accused do not have the copies of the relevant materials like complainant statements and other witnesses' statements before arguing the case, your lordship, before the trial court, prior to taking cognizance, your lordship.
Yes.
The purpose is, your lordship, that by not doing so, your lordship, my right, your lordship, that principle of natural justice has been violated, your lordship. For what purpose, on what basis, your lordship, argument will be advanced, your lordship? It has not envisaged, your lordship. And that is why, your lordship, the way, your lordship, the learned trial court proceeded, your lordship, in my humble submission, this is completely, your lordship, in violation, or it is doing violence to the provision of.
No, now whether cognizance has been taken.
No, your lordship, that is what, your lordship, without taking cognizance, your lordship, it will amount to, your lordship, reviewing his own order. He has gone back to, your lordship, the first stage again, your lordship. And now, hearing the complainants, your lordship, after examining the witnesses, your lordship, he will take cognizance, your lordship. We will not get any chance to advance our argument at this stage, your lordship, where that stage has already been over. Number 1, your lordship. Yeah. This is the first limb of our, and in fact, your lordship, 3 of the high courts has already decided this issue. One judgment of one of the high courts, your lordship, has gone up to the Apex Court. Apex Court did not interfere with that, your lordship. I will show that, your lordship. This small issue is involved, and this needs to be considered by this honorable court.
No. How would you be prejudiced? Because that is without hearing you, without giving you full opportunity, the court will be taking cognizance now
Lordship.
after examining.
The moment, your lordship, there is a violation of the statute, your lordship, I will be prejudiced. Because statute mandated something, your lordship, that will have to be followed, your lordship.
Yes.
The moment it is violated, I will be prejudiced. A valuable right will be taken away from me, your lordship, by doing so, your lordship. That's why, and your lordship will kindly see, your lordship, the one judgment, your lordship, is passed by the Karnataka High Court that went up to the Apex Court, your lordship.
You cited these.
Yes,
rulings before
we have, and the honorable court did not even
have you cited these rulings before the trial court?
Yes, your lordship.
What trial court?
We don't consider, your lordship. Your lordship has seen in view of the above discussions, meaning of the term cognizance by the honorable Apex Court, I incline not to refer to the judgment passed by the honorable High Courts relied upon by the proposed accused persons, your lordship. The issue has not been dealt with, your lordship. And it is not the issue of taking cognizance, or your lordship, what cognizance means, your lordship. This is, your lordship, in 2024, your lordship, exactly on the same point, your lordship. What will have to be done, your lordship. This is
So materials on which the courts would be taking
taking
cognizance
cognizance. I
shall
use
have,
that,
shall
your
have to be before,
before your lordship.
before the court, before giving you opportunity of being heard.
Lords, unless, your lordship, it will become an empty formality, your lordship.
Yes. Yes, what this judgment says.
It says, your lordship, para 8, the obfuscation generated in the case at the hand is with regard to the interpretation of section 223 of BNSS as to whether on presentation of the complaint notice should be issued to the accused without recording sworn statement of the complainant, or notice should be issued to the accused after recording the sworn statement. As the mandate of the statute is, while taking cognizance of an offense, the complainant shall be examined on oath. The proviso mandates that no cognizance of an offense shall be taken by the magistrate without giving accused an opportunity of being heard. To steer clear of the obfuscation, it is necessary to notice the language deployed therein. The magistrate, while taking cognizance of an offense, should have with him the statement on oath of the complainant, and if any witnesses are present, their statements. The taking of cognizance under section 223 of BNSS would come after the recording of the sworn statement. At that juncture, a notice is required to be sent to the accused as the proviso mandates grant of an opportunity of being heard. 10. Therefore, the procedural drill would be this way. A complaint is presented before the magistrate under section 223 of BNSS. On presentation of the complaint, it would be the duty of the magistrate concerned court to examine the complainant on oath, which would be his sworn statement, and examine the witnesses present, if any, and the substance of such examination should be reduced to writing. The question of taking cognizance would not arise at this juncture. The magistrate has to, in terms of the proviso, issue a notice to the accused who is given an opportunity of being heard. Therefore, notice shall be issued to the accused at that stage, and after hearing the accused, taking cognizance and regulate the procedure thereafter. Then 11, the proviso thereafter indicates that an accused should have an opportunity of being heard. Opportunity of being heard would not mean an empty formality. Therefore, the notice is sent to the accused in terms of proviso to subsection 1 of section 223 of BNSS shall append to it in the complaint the sworn statement of the witnesses, if any, for the accused to appear and submit his case before taking cognizance. In the considered view of this course, it is clear purport of section 223 of BNSS 2023. Your lordship, this is what.
When is the next date for you?
Tomorrow, your lordship.
For examination of
Yes, your lordship.
complainant has been examined?
No, not yet, your lordship. He will be examined, your lordship. That is why this has been fixed, your lordship.
Heard Mr. S. Bhattakur, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner, namely Shri Manoj Chauhan. Impugning the order dated 15/2/2025 and 27/10/2025 passed by the Court of London Chief Judicial Magistrate. Chief Judicial Magistrate, Kamrup Metro at Guwahati in complaint case number 78/2025, whereby the Guwahati stop. By the order dated 15/2/2025, the trial court, after receipt of the complaint, where is the complaint?
Your lordship, that is a page
What has been alleged?
That your lordship, by making certain statements which are false, your lordship, the page 21, your lordship will get it. 19, page 19. Page 19. Just first the next, your lordship, after affidavit.
The facts relevant for consideration of the instant criminal petition, in brief, are that you have made the complainant
Yes,
as
this part here.
respondent number,
Your lordship, respondent number 5, your lordship.
that the respondent number 5, Dr. Himanta Biswa Sharma, as a complainant, had lodged a complaint before the court of learned Chief Judicial Magistrate Kamrup Metro, alleging therein that the present petitioner has made certain defamatory statements against him. How newspaper came into picture?
These were published in the newspaper.
And the said defamatory statements were published in the newspaper, that is
Assamia Pratidin.
Assamia Pratidin. Stop. The complaint case, the said complaint case was registered as complaint case number 78/2025. And by order dated 15/2/2025, the trial court, without examining the complainant under section 223 of BNSS, issued precognizance notice to the opposite parties, including the present petitioner. Stop. It is pertinent to mention therein that the complainant appeared before the trial court in pursuant to the said notice and submitted his written objection. The main plea of the complainant before the trial court was that the precognizance notice cannot be issued by the trial court without first examining the complainant on oath and his witnesses. And otherwise, the statutory provision which has been newly incorporated as proviso 1, as first proviso to section 223 of the BNSS, would be a mere formality. However, by order dated 27/10/2025, the trial court rejected the plea of the petitioner and issued notice to the complainant and proceeded with the complaint case by issuing notice to by fixing the case on 12/11/2025 for examination of the complainant. Learned counsel for the petitioner has submitted that the first proviso to the section 223 is a new addition to the statute. There was no such corresponding provision in section 200 of the Code of Criminal Procedure, which is in pari materia with the provision of section 223. He submits that unless the materials on which unless the materials which the court shall take into consideration before taking cognizance are before the court, and copies of same are also provided to the petitioner at the pre-cognizance stage. The purpose of affording a pre-cognizance hearing to the petitioner pre-cognizance hearing to an accused under first proviso to section 223 would be a futile provision. He submits that the procedural requirement, he submits that the scheme of the statutory provisions contained in section 223 of BNSS is that after presentation of the complaint, it is the duty of the magistrate concerned to examine the complainant on oath and also examine the witnesses present, if any. And the substance of such examination should be reduced into writing. The magistrate has to thereafter, in terms of the first proviso, issue notice to the accused, who has to be given opportunity of being heard as to whether on the materials available before the court cognizance can be taken or not. However, if the complainant and his witnesses are not examined, no such material would be before the court or would be with the accused on his appearance after receipt of notice at pre-cognizance state. Therefore, apart from the complaint, he would not have any other material on the basis of which he could have objected to taking of the cognizance. In support of his submission, the petitioner, learned counsel for the petitioner, has cited a ruling of the Karnataka High Court in the case of Basana Gowda R. Patil versus Shivananda S. Patil, reported in 2024, SCC Online KAR 96/. I have gone through the petition along with the annexures filed by the present petitioner, as well as the submissions made by learned counsel for both for the petitioner. The contentions raised by the present petitioner seems to be reasonable and needs to be looked into by this court. Hence, issue notice to the respondents and call for the scan copy of the records of complaint case number 78/2025 from the Court of Learned, Chief Judicial Magistrate, Kamrup Metro. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 16th of December 2025. Interim relief is,
Lords, I will pray for an interim.
in the meanwhile, considering the submissions made by the learned counsel for the petitioner as discussed in the foregoing paragraph and importance of the issue raised in this criminal petition, further proceeding of complaint case number 78/2025 shall remain stayed till next returnable list accordingly.
For its reapplication, Lordship. He was arrested already 302 days in custody. Charge sheet submitted, now evidence of 4 witnesses have been examined.
Oximeter,
Yes.
what is your submission? No, I'll go through, but what is your submission? Are you objecting to bail or conceding, or what you have to say? You are victim. Victim has been examined.
Yes, victim examined, complainant was examined, and another 2 witnesses have been, but
State and money was recovered, some of them from the house of the that gate for employee and some of the from the storeroom of the bank, my lord. Then on the basis of his statement, my lord, basis of the statement of the my lord, the accused, my lord, that the arrested person, my lord, this branch manager and my lord cashier has been arrested. So we are in jail for 37 days today. So solely on my lord basis of the my lord, his confessional statement made before the police, my lord. So last occasion, my lord, they produced the case diary. They said that except his statement, there is nothing. Then they want to show some, my lord, the video clipping. But I don't know what they have done in video clipping. My lord, now I am not going on merit, my lord. Your lordship kindly see, amount has been, my lord, yet absolutely, my lord, on the basis of the statement of the.
How much amount was looted?
12 lakhs. My lord.
How much was recovered?
Same recovered, my lord. All money has been recovered.
Okay.
And there's.
And the main accused is behind the bar.
All, my lord, they are many is behind the bar, my lord, manager is behind the bar, and cashier is also behind the bar, and 37 days in jail, my lord, and money has been recovered, and a statement of the co-accused, my lord, that is, my lord, cannot be, maybe, my lord, in trial, my lord, that will be not counted. And my lord, no chance of, he's a very brilliant student, he's an engineer by profession, because of his, my lord, conduct, he's a very good, my lord, bank official, that's why he was given promotion to the branch manager, my lord. Now, my lord, unfortunately, he has been involved, my lord. So there is no chance of, my lord, tampering any record, my lord, because already money has been recovered and confessional statement has been made by the main accused. He also definitely suspended from the office and facing the trial, my lord. Facing the.
You are under suspension.
I'm in jail for 37, obviously, my lord.
No, but whether formal order of suspension has.
That I cannot, my lord, probably suspension, my lord, but that is cannot be.
My lord.
Yes.
Here I have received the case there, my lord. Here. Oh.
No, let us finish this.
Branch manager, I'm branch manager.
You are item number?
Because of his statement, my lord, we are arrested. No, his statement is already been recorded. That is there, my lord. He cannot escape from that, my lord. He cannot improve that, my lord.
Same case diary, na?
My lord, same case there.
Okay, yes, you may make.
My lord, same case, same police station case.
Let us hear him
My
also.
lord.
Your main plea is that you are arrested on the basis of co-accused statement
It-
and 37 days have lapsed. And money has been recovered.
What has happened is, once they came back from the lunch, they noticed the lock was dismantled and all. Now, the grade 4 employee, he informed the branch manager. Branch manager from outside the bank premises, he gave a call to senior management. Senior management said, you call the police, you inform them. Police came, then they entered the premises. The branch manager over the phone, he said that 12 lakhs rupees is missing. Obviously, he will be knowing because on the very starting of the day, he should know how much cash in hand is available in the bank premises. Now, when the police searched the premises, they found 9,50,000 rupees tucked away below a cupboard inside a carton box. So that was recovered from the cashier. An amount of 3,10,150 rupees was recovered. So totaling that, it comes to 12,60,000.
Cashier is not before us.
Cashier is before.
Cashier and bank manager.
The cashier's, his drawer was locked. It was found in locked condition. From inside there, the 3 lakh odd amount was found. Now totaling that, it comes to 12,60,000 something. That means the cash transaction in the very first half, that was also there. So our entire amount was recovered. Now they went to my premise. I am a grade 4 employee, daily wager. I reside at the very front of the bank. My marriage was coming up in the month of November end. Now for that
This
purpose,
9 lakh was recovered from?
inside the bank's premises below a cupboard.
Cartoon, inside the cartoon, my lord, in the
So
storeroom.
everything was found inside the bank premises. Now
Okay.
the police comes out, they visit my residence because I am a daily wage worker. I reside in front of the bank premises in my permanent residence. There, some construction work is going on because my marriage is coming up and my father has gathered 20 rupee and 10 rupee two note bundles totaling to 54,000 rupees. 20 rupee note bundle and 10 rupee note bundle that is available in the lower court's order. It is seized. 54,000 rupees, man. My learned senior is saying that is the bank's money. Now that is nowhere connected with the bank amount. Now, because of the construction
From you, only 54,000.
in my residence,
Okay.
20 rupee and 10 rupee note bundle kept for by my father because of my marriage is coming up. Now, because construction is going on, some renovation is going on in my house, police assumes that I use those cutting materials to break the locks and everything. And on the very same day, everyone has been arrested. It's not that my statement was taken on the spot and then they were arrested. Everyone was arrested on the very same day. And today is the 38th day, 39th day. So, my lord, everything has been recovered. What my learned senior friend has said. Further custodial detention might not be necessary because even a daily wage worker won't be allowed to go inside the bank premises now. My lord will examine the case diary. And my further custodial detention might not be
Yes.
because no loss has been caused to the bank.
Is there any CCTV footage?
My lord, here CCTV footage, my lord. Lordship, here is the, my lord, false case of theft, my lord. All of them pre-planned, my lord, for theft of the misappropriation of amount. of money.
Otherwise money was recovered.
Money was recovered, my lord. Here, what happened, my lord, on that day, my lord, CCTV was not working, my lord. Not working. On that day, my lordship is very interesting, my lord. It is to be noted that when our police team visited the bank on the day of the incident and directly checked the CCTV footage, it was found that the CCTV system was not functioning. During the time of the incident, the last available footage was recorded 9:30 to 10 AM. When the cleaning boy, that is my lord, fourth grade employee, my lord, Arihant Horizon Gullu has arrived at the bank. However, according to the bank employee statement, the CCTV system stopped functioning between 9:30 to 10 AM on the day of the incident. They stated that there was a brief power outage during that time, after which the system went off. Due to the exhaustion of the research balance, the CCTV did not automatically restart when the power was restored. The branch manager then instructed the cleaning boy to research the system. Therefore, at the time of incident, no CCTV footage was available for verification.
Otherwise,
IO has collected, my lord, sufficient materials against them, all of them, my lord.
okay.
And from
Heard
the
this.
statement of the, my lord,
Heard Mr. T.J. Mohanta, learned senior counsel, assisted by Mr. S. Alam, S.M. Mullah, learned counsel for the petitioner. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely
Sahil is the manager, my lord, he is the branch manager.
and where is the cashier?
Cashier Amardeep Roy, my lord, he is the
Amardeep
cashier, my lord. 24, item number 24, my lord.
Next item.
My lord.
And your item is?
28, my lord,
We are taking up three matters together.
Gullu, my lord.
क्या लिखा? Last line. The petitioner, namely Sahil Anjum, who has been detained behind the bars since 4/10/2025, within bracket for last 37 days, in connection with Mankashar PS case number 131/2025 under section 61 within bracket 2/305 within bracket A within bracket E /306/3165 /217/314/316 of BNSS. The gist of accusation in this case is that on 3/10/2025, who lost the affair?
I will lodge the FIR, madam. Because on the basis of the information given by the manager, I will lodge them.
One Akas Ali, SIF police, had lodged an affair before the officer in charge of Mankasar police station, inter alia, alleging that on that day at about 4:47 PM, he received an information from the branch manager of UCO Bank, Mankachar, within bracket, present petitioner, to the effect that on that day at about 12:10 PM, after closing the bank for lunch, when he left the premises, and while he returned back at 2:45 PM, he found some unknown miscreants have broken the grill lock of the bank and illegally entered inside, and reportedly 12 lakh of cash amount was missing. Stop. It is further alleged in the affair that during preliminary inquiry and interrogation of the bank's staff, it was suspected that the officials of the said banks were involved in planning the
FIR, my lord, during the interrogation of daily wages manager, Kullu, he confessed on that inquiry. Your lordship, and last para of the FIR, my lord.
No,
earlier part,
before, I'll come to that.
Earlier part.
क्या लिखा? Involved in the offense alleged Stop. Later on, during search of the bank premises, a cash amount of rupees 9,50,000 was found under a carton, and an amount of rupees 3 lakh where this 3,10,000
lakhs 10,000 150 from the case box of the cashier, madam. Case box of the cashier, madam.
was found in the cash box of the cashier.
Cashier, madam. And 54,000 from the
The police, during preliminary inquiry, also interrogated the daily wager cleaning staff, Mr. Arihant Harijan, alias Gullu, and who confessed that the whole entire incident was conspired and planned by the present petitioner.
and 54,000 also recovered.
And the conspired and planned by the bank manager as well as the cashier. The FIR further states that on search of the residence of the daily wage cleaning staff, and a cash amount of rupees 54,000 was recovered therefrom. No, stop. Learned counsel for the petitioner has, learned senior counsel for the petitioner has submitted that the present petitioners the present petitioner was arrested mainly on the basis of confessional state, mainly on the basis of the statement of the co-accused cleaning staff, co-accused, that is the daily wage earner Arihan Harijan, alias Gullu. And nothing apart from his statement is there on record against him. He further submits that the suspected missing amount of rupees 12 lakhs has already been recovered. And the petitioner is languishing behind the bars for last 37 days. He further submits that considering the period of detention undergone by the petitioner, he may be allowed to go on bail. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Mankachar PS case number, what is it?
131 of 2020.
131 of 2023, and has submitted that though a query has been posed by the court as regards CCTV footage available during the relevant period of time. However, he submits that on perusal of the case diary, it appears that during the relevant point of time, the CCTV surveillance camera were not functioning. He further submits that during investigation, sufficient incriminating materials have been found against the present petitioner. And
Objection.
what is the progress?
Madam, investigation is going on, madam. Not yet
Stop.
completed, madam.
Stop. He therefore objected to grant of bail of the present petitioner. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Though on the basis of the materials available in the case diary, the involvement of present petitioner may not be ruled out at this stage. However, considering the progress made in the investigation as well as period of detention of the present petitioner, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation, his further custodial detention may not be necessary for fair completion of the investigation of Mankachar PS case number 131/2025. Stop. Considering the above, in view of above, the above named petitioner is allowed to go on bail of ₹50,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Mankachar. Chief Judicial Magistrate South Salmara Mankachar with following conditions. Condition number 1 and 2. The item number 24, cashier's same order, and the 28 same order, the bail amount is 30,000.
Very pleased. In this case, trial court records were called for, my lord. This is a secret case, my lord.
What is the method?
Matter, your lordship may kindly see the FIR. FIR, your lordship will find at page 10, my lord. It was logged by the police officer, my lord. Lady police officer. Page 10.
103.
Yes, my lord. Your lordship, most respectfully beg to state on 19/8/2025, WSI Bornali Soikya informed me that on 12/8/2025, on getting information, went to the residence of Amrit Borua at Maupukuri Gaon, and Amrit Borua informed the applicant that he had the alternation with two of his neighbors. At the time, his father was not physically unwell, and was taken to hospital through 108 ambulance at Jorat Medical College Hospital. Thereafter, on 16/8/2025, he was discharged and was taken home. On 17/8/2025, Torun Bora had expired. WSI Bornali Soikya submitted an application to investigate the case, and so a case has been registered as Pulibor. Actually, it is UD case, not US. UD case number 12/25. Matter was investigated. During the course of investigation, postmortem report of the deceased Torun Bora was collected. It was stated that the death was due to coma as a result of head injury. Injury was antemortem caused by blunt force. Thereafter, death of Torun Bora was due to head injury. During investigation, taking evidence of witnesses, it was found that the accused person, namely Puneswar Kolita, Avinash Kakoti, Kolyan Kakoti, and others on 12/8/2005 entered the residence of Amrit Borua and his father, Torun Borua, as a result of which Torun Borua got unwell. On 17th, he expired. Therefore, a prayer was made to register a case. Accordingly, the case was registered by this policeman. There was no complaints from any other side. The police has registered the case, my lord. Now, charge sheet has been submitted. In the charge sheet, your lordship may kindly see. In the charge sheet, my lord, am I giving a copy?
Page number?
The charge sheet has not been enclosed, my lord, during investigation. After filing of this case, we have collected a certified copy of the charge sheet. Your lordship may kindly come to the charge sheet, page number 1, 2, 3. Facts disclosed during investigation. That is important. তদন্ত কালত ঘটনাস্থলী পৰিদৰ্শন কৰা হয়। গোচৰীয়া প্ৰমুখ্য সাক্ষী পদক মোকদ্দমা সংক্ৰান্তত সোধপোছ কৰা হয়। ই কাৰ্য জড়িতে 180 BNSS মতে জবানবন্দী পঞ্জীত লিপিবদ্ধ কৰা হয়। ঘটনাস্থলী এখনি ফুল মূল মানচিত্ৰ অংকন কৰা হয়। পদকীয়া মোকদ্দমা সংক্ৰান্তত পুছ কৰি কৰা হয় আৰু মোকদ্দমাৰ লগত জড়িত থকা দুজন পদকীয়া শ্ৰী পুণ্যেশ্বৰ কলিতা এণ্ড অবিনাশ কাকতি মোকদ্দমাৰ সংক্ৰান্তত গ্ৰেপ্তাৰ কৰি জেল হাজতত প্ৰেৰণ কৰা হয়। সাক্ষীবাদী সোধ-পোছ ক্ৰমে তদন্তকালত পোৱা যায় যে মৃত তৰুণ বৰুৱাক কোনো লোকে মূৰত আঘাত দিয়া নাই। So nobody assaulted that person. যদিও কাজিয়া ভাঙিবলৈ যাওঁতে ঠেলা হেঁচাৰ মাজত এটা বাঁহৰ খুঁটাত পৰি আঘাতপ্ৰাপ্ত জখম। পৰৱৰ্তী সময়ত উক্ত জখমৰ পৰা তেওঁৰ মৃত্যু হোৱা বুলি নিশ্চিত হয়। এই মোকদ্দমা এজাহাৰ উল্লেখিত কল্যাণ কাকতি আৰু পিতা সোৰেন্দ্ৰ জিলাৰ মোকদ্দমা জড়িত থকাৰ কোনো সাক্ষীবাদী প্ৰমাণ নোহোৱা গ'ল। সেই উক্ত কল্যাণ কাকতি এই মোকদ্দমাৰ পৰা দিবলৈ মহামান্য আদালতে প্ৰেৰণ কৰে। So no case of 102, nothing, my lord. It's a case of simple heart, my lord. That too.
What is 105? Culpable.
105 is not attempted. That is culpable homicide, not amounting murder. That is not a case of culpable homicide because in the melee, she free fell. Nobody assaulted him.
Since when you are behind the bars?
I was in a jail, my lord, since 12/25/8/2025. That I would completed more than 50 days now. Around 25/8/25/9/30 plus.
Yes.
40.
My lord, here I have gone through the record, my lord. Here, in PM report, my lord, death was due to coma as a result of head injury, my lord. And here is the scalp, my lord, confusion of size 10 cm into 8 cm, my lord. And here, total 15 witnesses in the charge sheet, my lord. And the case is at the stage, my lord, production stage, my lord, 12/11/2025, my lord. Here, my lord, although it was 103, my lord, charge sheet submitted under section 105(3) subsection 5, my lord. And from the statement of the witnesses, my lord, under 180, my lord, all of the witnesses said that, my lord, there is a quarrel between the, my lord, accused person and Amrit Purva, my lord. When his father went there to, my lord, interrupt the, my lord, quarrel, my lord, then he fell down, my lord. Whether it was some of them, my lord, hit or not, my lord, that is not clear, my lord, but said that, my lord, in the shuffle, my lord, he has fall down, my lord, and injured, my lord. Later, he was taken to the hospital, my lord, and thereafter released, and then thereafter he was died next day, my lord.
The prosecution case is nobody has caused injury to the injured man. Accidentally he fell down. As a result, he got injured.
In the shuffle, my lord, he
Heard Mr. P. Kotoki, learned counsel for the petitioner. Petitioners. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners, namely Punneshwar Kolita and Abhinash Kakoti, who are detained behind the bars since 28/8/2025. Within bracket for last, how many days?
It's more than, he will complete my 25/9, 1 month.
78 days.
78 days.
For last 78 days. The gist of accusation in this case is that on 25/8/2025, one Chitralekha Gogoi had lodged an FIR before the officer in charge of Ulibor Police Station, inter alia, alleging that during inquiry conducted in respect of Ulibor PS case number, Ulibor UD, Ulibor PS UD case number 12 of 2025. It came to the notice of the inquiry officer that the deceased Tarun Barua, who had expired on 17/8/2025, suffered antemortem head injury caused by blunt force impact. And it was found that at the time of it was found that at the time of death of the at the time of sustaining the said injuries, the present petitioners and one Kalyan Kakoti and some others were there in the residence of the deceased, resident of one Amrit Purva. Learned counsel for the petitioner submits that though the case was initially registered under section 103 of BNSS, however, no ingredient of the said offense is there either in the FIR or other materials on record. He further submits that in the charge sheet which has been laid under section 105 of the 105 within 105/35 within bracket 5 of BNSS. It is clearly indicated that there is no witness implicating the present petitioner of any assault or any act by which any act which resulted into death of the deceased. Rather, it is revealed during investigation that there was an altercation between the accused persons and some other
Son of the deceased.
Amrit Burwa.
and
Amrit Purva.
one Amrit Burwa. And when the deceased tried to interfere in the same, he sustained, he fell down and hit a bamboo post, sustaining injuries on his head. Stop. Learned counsel for the petitioners has submitted that the petitioners are detained behind the bars since 28/8/2025, and as they are ready to cooperate in the trial. Stop. On the other hand, learned additional public prosecutor also submitted on similar lines as regards the facts. What is your submission? Where is their negligence?
My lord, regarding my lord, negligence, my lord, there is a altercation, my lord, I have already submitted, my lord, there is quarrel took place, my
Stop.
lord, any interrupt, my lord. Then somehow. my
As
lord,
regards the facts stated by learned counsel for the petitioners. Stop. Considering the above stated fact, considering the submissions made by learned counsel for the parties as well as nature of the offense involved in this case and the period of detention undergone by the petitioners, this court is of considered opinion that if the above named petitioners cooperate in the trial, their further custodial detention may not be necessary for fair completion of the trial. Hence, both the above named petitioners are allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of
Oxygen, my lord, Durrani.
learned Chief Judicial Magistrate Jorhat with following conditions. Number one and number two. This bail application is accordingly disposed.
Next, I 26, for like 82 days, he is there. After the also listed but of it, to go to Mala, from there, they are from more money, 82 days. he is there. 26, I think.
No, leftover matters, wherever there is interim order. Wherever there is interim order will remain. And wherever there is any urgency, please approach registry.
Item number 26, they have to 82 days in jail.
Am I not clear in conveying my